Please, Your Lordship, with your consent of the other side, I beg to mention item number 19. Senior Counsel Mr. N.C. Das is having some personal difficulty today, Your Lordship.
Senior Counsel, Mr.
N.C. Das
Ah,
is having some personal difficulty
Okay.
today.
A prayer is made on behalf of Mr. N.C. Das, learned Senior Counsel, appearing for the petitioner. A prayer is made for adjournment in the ground that the learned Senior Counsel, Mr. N.C. Das, is having some personal convenience today. Prayer accepted. Registry to list this matter again
After a week.
after a week on a date period expired.
Right,
All
Mr.
right.
Lord. I beg to mention item number 11, my lord. My lord, I am appearing on behalf of N. Sarkar. So my lord, he feels sick and he went to.
Okay. Prayer is made on behalf of Mr. N. Sarkar for an adjournment in the matter on the ground that he is indisposed.
Yes, my lord.
Prayer is not objected to by the learned counsel for the respondents. Accordingly, registry to list this matter again after 16 matter. When?
As you wish, my lord.
Next week?
Next one.
In the next week. After a week, a date did 26.
Hi,
May I
lord.
please it? I beg to mention item number 11 of court number 22, my lord.
Court number 22.
Yes, my lord. Not a matter relates to non-payment of family pension, my lord. Therefore, I am paying a debt, my lord.
It is.
11.
22, what happened?
My lord, date may be given, my lord, on 27, my lord.
If you want to do it with me before me.
Okay, my lord, then.
Otherwise, if there is urgency, what is the urgency here?
My lord, matter relates to non-payment of family pension, my lord.
Oh, non-payment?
Family pension.
Okay. That will come. You make a mention. Because today, there is no urgency that it has to be done today only. Is there an urgency that it has to be done?
Your lordship, suppose to take, my lord.
No. I'll take it if there is a extreme urgency in the matter.
Then, my lord.
Cannot be said to be that if we don't do it today, there will be a big...
Yes.
Let it come, make a mention tomorrow before the court and then see what happens.
Obliged, my lord.
Yes.
May please, Lordship. Lordship, with the consent of the other side, I beg to mention item number 32, Lordship.
30?
32, Lordship.
Why?
Lordship, the matter is pending before the mediation, Lordship.
We'll have
So
to
next-
pass an
next-
order for extending the period of mediation. That's all. We'll pass it when it reaches.
My lord,
Yes.
may I mention, my lord? My lord, online.
Yes, Mr.
May I
Singh.
mention, with the consent of the other parties, may I mention item number 20 and 21?
Why?
Filing rejoinder, my lord.
Mr. Singh, what is your case here?
My case is, my lord, that there was an inquiry conducted way back in 2016. The report was concluded. The authority concerned thereafter initiated fresh inquiry, my lord, in 2017. Then stopped again 2018 without referring to 2016, my lord.
What is the allegation against you, Mr. Singh?
That I have submitted fraud admit card, my lord, or
Of HSLC admit cards.
matriculation, my lord.
That is an admitted position now because the
No, my
assessment
lord.
authorities have brought it on record.
No, my lord.
Then what?
The rejoinder, that is why we want to
No.
bring
Tell
to
me
the
the reason. Tell me the reason. What is the material that you have which will demonstrate that this is not a false document?
My lord, we have already provided and we want to bring on record the certificate which has been provided by the school where I studied and where from I appeared, my lord.
School certificate will not
No,
go.
my lord, the certificate they are relying, it was collected in 2019. What about the 2016? They can make inquiry, my lord, but how many times? 2016, it gives me a clean sheet, my lord. I will kindly provide me the opportunity to bring on record the
How long will
rejoinder,
you
my
take?
lord, with
How
a
long
fixed
will you
date,
take?
my lord.
How long will you take to file?
Any date, my lord. 2 weeks I will submit, my lord, because I was not feeling well, my lord, for some days.
On the prayer of Mr. S.K. Singh, learned counsel for the petitioner, the matter stands adjourned to 30/3/2026 to facilitate filing of a rejoinder in the matter on or before 27/3/2026. No further adjournment shall be granted to the petitioners to bring on record their rejoinder in the matter. Registry to list those matters again on 31/3/2026. 31/3/2023. Okay, Mr. Singh. 31.
Highly obliged.
May I please, your Lordship? Lordship, I beg to mention item number 7. In this case, Lordship, I was supposed to file a written argument. Lordship, I pray for 2 to 3 days time to file the written.
But that was given to you long back.
Lordship,
And what
that
is
is
the
there.
case?
I couldn't find the recruitment rule.
This is pay parity of Assam Rifle.
Yes, Lordship.
They have brought it out in their affidavit in the manner in which this was done. Nothing.
Lordship, just
That opportunity was already given to you. This is
Lordship,
a
that is
matter
there,
of,
but the recruitment
this
rule,
is a matter of 2016.
16, Lordship. Lordship, only for 2 days time, Lordship. Because the recruitment rule has
Lordship, otherwise, Lordship, I am ready, Lordship. If you-
only 2 days time, Lordship.
I can't read this file again. That's the problem.
Lordship, problem is that the way I have drafted the petition, it is very clumsy. So,
We have
Now-
got the essence of that. So
Lordship,
nothing
that
more is.
recruitment rule, I have not got the BSF recruitment rule. That was not.
Hey, BSF, the educational qualifications,
Lordship,
the posts are totally different from your service. In your service, that post that is there, which you are claiming parity with the BSF thing,
Yes, Lord.
you are claiming redesignation of the post
Yes,
as well as the salary. The qualifications are admittedly different.
Lordship, the qualification that ITI,
You were a recruit as a rifleman general duty.
the nail dated,
Then you were remastered as a electrical cadre.
Yes, Lordship, technical getter.
Now you are getting all the benefits. I think 2-3 promotions have also been given to you. Now you say that the moment you qualify those class 1, class 2, class 3 examinations, you have to be promoted. I don't find
Lordship,
that.
In that way, the donation was decided.
Dinesh is in a different context altogether. That cannot have a
Lordship,
universal application.
Lordship, regarding this qualification, that is why I am searching for the recruitment rule of the BSF and
You should have searched in 2016, not today.
Lordship.
That is your projection into the writ
Yes,
petition.
Lord.
So that material should have been there.
No, that incomplete material is with me. That is only 2 days time, Lordship.
On the prayer of Mr. S.N. Amuli, learned counsel for the petitioner, registry to list this matter again on 31/3/2026. No further adjournment shall be granted in the matter.
Matters.
oblige, Lordship.
I can't read this file again this week.
Lordship,
I'll read it on Monday again.
Lordship,
And something new may again come out.
Lordship.
Lordship. Oblige, Lordship.
I've lost the
Get
contact.
those decisions wherein it is said that parity designation is an executive function and the court.
I have bought the same.
Ah.
My Lord Justice Himakuli judgment,
Ah.
as well as MR Sir's judgment, my Lord
Ah.
Justice.
Place that.
I have.
Give the citations to Madam.
Lordship, Lordship, I'll. Oblige, Lordship, oblige.
Mr. Singha, we'll finish the top of the list matters and then come and deliver your order. No, copy. Just give the citations. Citations. Copy will get misplaced. Just give the citations.
Wait, please, Your Lordship. My lord, I have filed an amended petition, my lord. Petition for amendment, it was filed on 11/10/2023. But
That is rejected. Now you can make your submissions with regard to
on the merit of the case,
merit.
amendment is correct, rejected.
Item naturally 2016 matter. You are only seeking the records of the appointment order. We deem that he is appointed. What more is required? You make your submissions on merit.
15 matter, not
So
16.
my lord, my first submission is this, my lord. I belong to family of Ga Bura. that point is not considered by authorities below, my lord.
Yes, then
That is the point, my lord. That
Only.
is, only point, and it is the stand of the authority is this, that my opponent, respondent number 6, has higher qualification. But at the time of advertisement, my lord, there is no qualification mentioned. So I read up to class standard 9. So, my lord, only it is considered that he is higher in qualification, so he will be appointed. On that,
he
my
has
lord,
a
the
graduate
case was
qualification.
rejected.
He has a graduate qualification.
Graduate qualification.
Any case law on this point?
My lord, on this point, my lord, my case law is this, my lord.
What a graduate.
2004 GLT. Sorry, my lord, 1992, 1 GLI.
Mhm.
1992, 1 GLR.
92, 1 GLR, my lord, para 4 may be looked into, my lord.
1992, 1 GLR page.
1 GLR page 89.
Para?
Para 4.
Yes. What does it say?
My lord, regarding 162, instruction 162A states inter alia that Ga Bura shall be appointed by competent authority, namely the sub-divisional officer. It further states that in the matter of appointment of Ga Bura, the authority shall take into consideration the claim of family of the late Ga Bura, the views of Mujadar,
That is 162.
suitability of the position of the post. The instruction makes it clear that, this is important, my lord. The instruction makes it clear that the post of Ga Bura is a civil post. Ga Bura shall be entitled to be protected him under Article 300A of the Constitution of India. Provides for the appeal to the Deputy Commissioner. So, my lord, my humble submission before your lordship, that family, it is a civil post, my lord, an appointment.
You have the decision of Rajeshwar Das with you?
It is not a hereditary post, my lord.
Rajeshwar Das, my lord.
Ga Bura post is not a hereditary.
Rajeshwar Das is taken into consideration wrongly, my lord, because he was.
You have that decision with you?
Yes, sir.
2006.
No?
2006, 4 GLT 925.
Rajeshwar Das, my lord, it is of 2004 to
2006, 4.
2004 to GLT, my lord. Rajeshwar Das,
That's a single bench.
my lord. So, my lord, that Rajeshwar Das is taken into consideration to deprive me. But my humble submission before your lordship, that decision will not.
Just 2006, 4 GLT. 9. Party number.
Yes. 2006 4 GLT 173. Page. Page 173. That's only 73 or 173. Rajeshwar Das. Page 173.
This is. Dear, the issue was whether he was a member of that family or not.
Oh, my lord,
That's what you want to project.
yes, my lord. That Rajeshwar Das has been taken into consideration. That he is the nephew of Ga Bura. And it is decided that nephew will not come in zone of consideration. By that, my lord, by that decision, my lord, my case cannot be defeated.
Okay.
Yes, my lord.
Anything more?
This is the point, my lord, that my grandfather was Ga Bura, my father was Ga Bura. That claim of family is totally ignored, my lord. Taking into consideration the graduate qualification, and graduate qualification, my lord, in the concerned
Minimum
advertisement, that was
qualification
not
is
mentioned.
required.
That was not mentioned at all. Why that if it is not mentioned in the advertisement, my lord, if it is not mentioned regarding qualification in the advertisement, then how that I may be defeated?
It may be a factor for the selection committee to look into when they are considering the candidates. Oh, he's a graduate. Give him 2 marks more. That's a consideration. But it cannot be a criteria.
That cannot be a criteria. Another thing is this, my lord. If my lord, the claim of the family is totally ignored, my lord, will it be a proper decision?
Okay. Yes. Yes, Mr.
That's why, my lord, his cases, my lord, as per this, my lord, Rayeshwar Das, my lord, the Ga Bura post is not a, my lord, is a government post, is not a hereditary, my lord, nobody can claim. No, only can claim for a, my lord,
What
different.
about the argument of Mr.
Sheikh.
Sheikh that 162 mandates a consideration for the candidate who is from the family of the Ga Buras.
But he is a nephew, he is not a son or daughter.
No, he is a son.
I am a son.
No, he says, my lord, nephew,
No,
and even though, my lord,
No, he's a
consideration,
son.
this Rayeshwar Das case,
Rajeshwar does forget it.
so, my lord, his case is, my lord, additional mark is given or not, my lord, record is not with me. So I cannot say whether being a member of the Ga Bura, whether he has got any additional mark or not.
I know that. Whether additional marks have been given on.
But I don't know, my lord.
I have not read deeply.
No, my lord, affidavit says, my lord, he secured the second position.
Who?
My lord, the petitioner.
Petitioner.
Yes.
Okay. Yes, you are the respondent number
6.
6. What is your case?
Performance the interview matter.
Ah.
And I was appointed on 2009 matter. 16
20?
years already completed matter.
Huh?
17 years matter.
When were you appointed?
28 2009 matter.
28 2009. You're working.
Matter. 16 years completed matter. And I was appointed on the basis of the matter.
Merit.
Interview matter. Interview. The matter in the democratic country matter. Parents on the basis of matter. Headed post matter. This is not the desired matter.
The government was open to all.
But Mr. M.A. Sheikh, Learned Counsel. Mr. Sheikh, we'll have to dismiss your petition.
My lord.
Because that plea of yours, that you were not considered as that the family, that you are belong to a family, was duly considered. There were 10 marks allotted for that purpose and you were given the full 10 marks.
So even though he's...
And that is available in the review order. And you have not dealt with that in the writ petition.
My lord, my humble submission before your lordship, 10 marks for my family background. But this, how he will negate my 10 marks, my lord.
He has given you, and thereafter
My lord,
the law now
my
is,
10 marks.
Mr. Sheikh, the law now is with the decisions that have come up after Rajeshwar Das, that this is a preference to a member of a family of a Ga Bura.
Right.
This preference will come in when both of you score the equal marks.
Equal marks.
If you score the equal marks, then you will get the preference. Otherwise, you have got no right. It's open.
Now my point before your lordship, that if I get equal marks, how the respondent number 6 get more marks than me?
That you hear.
More marks than me. How? How he will get?
That marking is not, he has not given any marking
My lord.
per se for the graduate qualification. But
My lord,
his graduate qualification was considered while marking him in the selection process, and we find no error in that.
My lord, then my 10 marks give no consideration. Because, my lord, he is a graduate.
With that 10 marks
My lord,
also, you don't come.
Your lordship will consider that he was considered. I was given 10 marks. how that 10 marks will be negated by respondent number 6? Because in the advertisement, my lord, there is no qualification criteria. How it is decided? So my 10 marks will go.
Okay,
My 10 marks will be negated
we are considering.
because he is a graduate, but graduate qualification is not the
We are
condition
considering.
precedent in the advertisement.
We are considering it, Mr.
My lord.
Please have a.
My lord.
Heard Mr. M. A. Shekhar, counsel for the petitioner, also heard Mr. T.C. Shutia, additional senior government advocate, appearing for the respondents number 1, 2, 3, 4,
7.
5, and 7. Also heard Mr. R. Hazarika, learned counsel, appearing for the respondent number 6. The petitioner in the present writ petition has presented a challenge to the selection and appointment of the respondent number 6 as the Ga Bura bracketed Ground Pradhan in village Bodla under Nagarbera Mauza, right? Village Bodla? Bodla Pothar. Bodla Pothar in under Nagarbera Mauza. Pothar, huh? Also, wide and order dated. Where is your that appointment order here? Appointment order not given.
My lord, appointment order.
Order wide and order dated.
That will be in record, my lord.
28/2009. So, the facts in brief requisite for adjudication of the issue arising in the present writ petition is noticed as under. The petition.
My lord, I may be excused regarding my amendment petition, my lord.
I'll deal with it.
Your lordship said that it is rejected.
I'll deal with it.
With ground, my lord, that may be rejected.
Huh?
With ground.
Yes, sure,
Yes,
naturally.
my lord.
As under full stop. The petitioner in the writ petition has projected that he belongs to a family of Ga Buras. His grandfather was initially appointed as a Ga Bura of was initially appointed as a Ga Bura of Bolot Pathar, and thereafter the said appointment was given to the father of the petitioner. Also, upon the death of the father of the petitioner, the post of Ga Bura becoming vacant, the petitioner was engaged on ad hoc basis for discharging the duties of Ga Bura of the said village. Full stop. With the said background, the petitioner, in response to an advertisement dated 14/5/2008, issued by the subdivisional officer, issued by the office of the Deputy Commissioner, Kamrup, Gauhati, inviting application from eligible candidates for filling up for recruitment to the post of Ga Bura of village Bodla Pathar under Nagarbera Mauza, the petitioner submitted his application. The respondent number 6 herein had also submitted his application for recruitment as Ga Bura against the post advertised, while said advertisement dated 14/5/2008. The selection committee as constituted in the matter after considering the cases of the candidates appearing before it, including the petitioner and the respondent number 6, proceeded to recommend the name of the respondent number 6 for appointment as Ga Bura, also advised by said advertisement dated 14/4. 14/5/2000. So, the petitioner being aggrieved by the said appointment affected in respect of the petitioner of the respondent number 6 had assailed the same by way of instituting a writ petition being WPC number 361/2008 before the said writ petition was permitted to be withdrawn by the learned counsel for the petitioner with liberty to approach the appellate authority by way of filing an appeal. They said order permitting the petitioner to withdraw the appeal was so passed on 19/12/2008. The petitioner thereafter instituted an appeal before the appellate authority. However, the said appeal came to be rejected while order dated 18/8/2009. The petitioner thereafter submitted an appeal, a review petition before the submitted an
Second appeal. Second appeal to the Commissioner Division.
submitted a further appeal before the Commissioner of Lower Assam Division, Gauhati. So the same was rejected by the said authority by an order dated 23/4/2010. So next, the petitioner being aggrieved by the disposal of his appeal by the Commissioner, Lower Assam Division, proceeded to file a review petition before the Government of Assam in the Revenue and Disaster Management Department. They said a review petition was considered and disposed of while order dated 18 were considered and disposed and rejected while order dated 18/11/2014. Being aggrieved, the petitioner has present a petition. At this stage, it is to be noted that the petitioner had filed an interlocutory application being IA-C number 3153/2023, praying for amendment of the writ petition, amendment of the prayer portion of the amendment of the writ petition. The said interlocutory application has been dismissed by this court by a separate order passed today. Also, Mr. M.A. Sheikh, learned counsel for the petitioner, after reiterating the facts noticed herein above, has submitted that in terms of the provisions of clause 162 of the executive instructions under the Assam Land Revenue Manual, the petitioner herein being a member of the family of the Ga Buras is entitled to be extended with a preferential treatment with regard to appointment against the post of Ga Bura, which was earlier held by his predecessors. Mr. Sheikh submits that the petitioner, admittedly being the grandson and son of the erstwhile Ga Buras of the same village, the respondent authorities, by invoking the provisions of clause 162A, ought to have proceeded to appoint the petitioner against the post of Ga Bura as advertised by the advertisement dated 14/5/2018, subject to the condition that the petitioner was not otherwise ineligible for such appointment. Mr. Sheikh submits that the materials brought on record would reveal that the petitioner had the minimum requisite qualification, educational qualification for being considered for appointment as a Ga Bura in pursuance to the advertisement dated 14/5/2018, and there is nothing brought on record with there is no adverse material brought on record by the respondents which would otherwise have the effect of barring the appointment of the petitioner herein as a Ga Bura. That's your basic submission. Next, Mr. Sheikh submits that a perusal of the materials brought on record would reveal that although the minimum educational qualification prescribed was class 8 pass. What is the minimum qualification prescribed?
Not mentioned, my lord, in the advertisement.
There was no mention of any minimum educational qualification in the advertisement issued, comma, the consideration of the case of the petitioner for such appointment would reveal that he, being a class 9 pass candidate, the said qualification was within the minimum qualification so mandated for consideration of the case of a candidate for appointment against the post of Ga Bura. He submits that the materials brought on record reveal that the selection committee, by construing the graduate qualification processed by the petitioner, were swayed in the matter, and it is only on the said on noticing the said qualification, graduate qualification possessed by the petitioner, that by the respondent number 6, that he came to be recommended for appointment on compassionate grounds. Recommended for appointment as Ga Bura against the post advertised by the advertisement dated 14/5/2018. He submits that there being no requirement of any qualification being prescribed in the advertisement in question, comma, the respondent authorities could not have, while carrying out the process of selection, introduced a fresh criteria of requiring candidates to have a graduate qualification for being recommended for appointment against the post of Ga Bura as advertised in the matter. Also, he submits that the consideration extended to the petitioner, to the respondent number 6, basing on his graduate qualification, is a criteria introduced by the authorities after the advertisement in question was so issued, which is clearly impermissible. Okay? So, Sheikh, anything more?
And one thing, my lord, in the advertisement, your lordship will see page 23.
Hmm. Hmm. Hmm.
23, my lord, your lordship will be pleased to see the advertisement said name and address of the applicant, father's name, relationship with ex Ga Bura. So, my lord, this is taken into consideration that even in advertisement that relationship of ex Ga Bura, that is a point. And regarding educational qualification, my lord, only said educational qualification along with certificate.
Okay, done.
So I read up to class 9. It's not that I am not
I have dealt with
at
it.
all. Yes, my lord.
Also, per contra, Mr. T.C. Chutia, learned counsel for the petitioner, submits that the post of Ga Bura cannot be considered to be a hereditary one. Also, he submits that even the member of the family of the Ga Bura is also required to participate in the selection process along with other candidates whose predecessors were not Ga Buras. Mr. Chutia submits that in the selection held, the selection committee had assigned 10 marks to candidates whose family members were holding the post of Ga Bura earlier. He submits that the set 10 marks as assigned in the matter was awarded to the petitioner hearing, and it is a petitioner hearing by construing that he was a member of the family of the erstwhile Ga Bura. Also, Mr. Chutia submits that the preference required to be extended to the family member of a Ga Bura for the purpose of his selection as Ga Bura, a selection against the post of Ga Bura is mandated to be so extended only when such candidate who is a family member of the ex-Ga Bura and another candidate who does not have the set relationship, who is not a member of the ex-Ga Bura, scores equal marks, and in such a situation, the candidate whose family, whose predecessor were Ga Buras would be extended with a preference, and he would be appointed in the matter. Also, Mr. Chutia submits that in the present case, the petitioner and the respondent number 6 had not scored equal marks even after the petitioner was granted 10 extra marks, bonus marks, for being a member of the family of the Ga Bura. Mr. Chutia, with regard to the submissions made by Mr. Sheikh that the selection committee had proceeded to recommend the name of the respondent number 6 solely basing on his educational qualification, solely by reckoning his graduate qualification. Chutia, with regard to the submissions, has submitted that the said submission is clearly misplaced inasmuch as the selection committee during the interview process had, for the purpose of judging the suitability of the respondent number 6, also considered his higher qualification and thereafter awarded marks in the matter to the respondent number 6. Mr. Chutia submits that the respondent number 6 was not selected solely basing on his graduate qualification, but was so done after an overall assessment of his suitability was made by the selection committee, wherein the educational qualification was also one of the criteria that was considered by one of the factors that was considered by the selection committee members. Also, Mr. Chutia submits that the appellate authority as well as the reviewing authority having rejected the same very pleas raised in the present writ petition by the petitioner, the present writ petition would not mandate an acceptance. The claim made in the present writ petition would not mandate an acceptance. Also, Mr. R. Hajorika, learned counsel for the respondent number 6, by adopting the arguments advanced by Mr. T.C. Chutia, learned additional senior, has submitted that there is no irregularity committed in the recommendation made in favor of the petitioner and accordingly his appointment as a Ga Bura, which was effected. Yes, Mr. Hajorika, when were you appointed?
2009.
20. Effected on 28/2009, would not mandate an interference in the matter. Accordingly, he praised that the petition would mandate to be dismissed in limine. I've heard the learned counsel for the part and peruse the materials available on record. The facts as noticed herein above pertaining to the process of recruitment to the post of Ga Bura is not in dispute. Also, the petitioner not being appointed as a Ga Bura in pursuance to the selection held in terms of the advertisement dated 14/5/2018, had submitted initially an appeal in the matter before the Deputy Commissioner. The Deputy Commissioner, the Jurisdictional Deputy Commissioner, by order dated 18/8/2009, proceeded to reject this appeal preferred by the petition by holding that there was no irregularity committed in the selection process for the post of Ga Bura, Podla Pathar, as advertised via the advertisement dated 14/5/2018. In the advertisement, in the said order, it was also highlighted that the respondent number 6 herein had scored the highest marks, while the petitioner had was placed in the second position in the recommendations made by the selection committee in the matter. So, the petitioner being aggrieved by the same by the said order dated 18/8/2009 had preferred a further appeal before the Commissioner, Lower Assam Division, Gauhati. The said appeal on consideration was rejected, while an order dated 21/4/2010 and the appointment of the respondent number 6 was confirmed. Also, the petitioner thereafter instituted a review petition before the Government of Assam in the Revenue and Disaster Management Department against the order passed by the order dated 21/4/2010 passed by the Commission of Lower Assam Division. The said review petition was considered, was given a final consideration, by an order dated 18/11/2014. So, on such consideration being made, the said appeal came to be rejected. The said review petition came to be rejected. A perusal of the said review, the order dated 18/11/2014 reveals that the petitioner, as well as the respondent number 6, were given a due opportunity of hearing placing their respective stand in the matter before the reviewing authority had passed the order dated 18/11/2014. Also, the challenge of the petition of the petitioner, the ground of challenge, first ground of challenge of the petitioner were to the appointment of the respondent number 6 as a Ga Bura of the village in question is that such appointment was effected without giving due weightage to the preferential treatment required to be extended to the petitioner being a family member of the family of the ex Ga Bura. Mr. Sheikh had submitted that the provisions of clause 162 and 162A of the executive instructions under the Assam Land Revenue Manual clearly mandates extension of such preferential treatment to the family, to a candidate who is from the family of ex Ga Bura. Also, it is today a settled position of law that the preferential treatment as contemplated under the section of clause 162A of the said executive is a preferential treatment required to be extended, a preferential treatment which would be applicable provided the petition about the candidate from the family of ex Ga Bura and a candidate who does not have any such relation appointed as a Ga Bura earlier scores equal marks in the selection process for appointment against a post of Ga Bura. It is when the said two candidates score similar marks, same marks, comma, the candidate belonging to the family of the ex-Ga Bura is given a preferential treatment and he is recommended for appointment on compassionate recommended for appointment as Ga Bura against the post so advertised. Also, in the case on hand, this court finds that the petitioner had scored marks lower than that of the that scored by the respondent number 6 in the connected selection process. The said contention as available in the matter in the orders of the reviewing order dated so and so in the order dated 18/8/2009 and 18/11/2014 passed by the Deputy Commissioner, Jurisdictional Deputy Commissioner, as well as by the government in the Revenue and Disaster Management Department have not been disputed by the petitioner in the writ petition. The petitioner in the selection process is found to have been awarded 10 bonus marks for the fact that he was a member of the family of the ex-Ga Bura. The petitioner accordingly started in the said selection process with an added advantage. However, with the said advantage also, the petitioner could not score a mark over the respondent number 6, who in the final analysis was found to be more suitable on merit by the selection committee. Accordingly, the claim of the petitioner that he was required to be appointed against the post of Ga Bura advertised by the advertisement dated 14/5/2018 by extending to him a preferential treatment in the considered view of this court would not mandate an acceptance inasmuch as the said preferential treatment, as noticed herein above, would come into play only when the petitioner had scored equal marks with the respondent number 6 herein, which admittedly is not the position obtaining in the selection process. The petitioner being placed in the second position on merits below the respondent number 6. Full stop. Having drawn the said conclusions, this court would now examine the second contention raised by Mr. M.A. Sheikh towards assailing the selection and appointment of the respondent number 6 herein. It is the contention of Mr. Sheikh that the advertisement having not laid down any minimum qualification as a eligibility criteria for applying against the post of Ga Bura, the selection committee ought not to have proceeded to recommend the case of the respondent number 6 herein only by reckoning his graduate qualification. This court has examined, they said, has perused the materials available on record for the purpose of appreciating the said contention raised by the learned counsel for the petition. Also, on a perusal of the materials brought on record, this court finds that there was admittedly no minimum educational qualification set out in the advertisement. The petitioner, being only a class 9 pass candidate, and his case having been found to be eligible, and he being found by the authorities to be eligible for consideration against the post of Ga Bura, this court finds that the qualification of class 9 pass insofar as the recruitment process in question in the present proceedings is concerned is also within the minimum educational qualification mandated for extension of such consideration to a candidate applying in pursuance to the advertisement dated 14/5/2018. Also, this court finds that the selection committee, while interviewing the respondent number 6 and while assessing his suitability for the post of Ga Bura as advertised as involved in the matter, had also reckoned his graduate qualification while for the purpose of assigning to him marks. Such reckoning of the educational qualification in the considered view of this was not the sole such reckoning by the selection committee of the graduate qualification of the petitioner of the respondent number 6 was not the sole factor basing on which the recommendation in favor of the respondent number 6 came to be made, but was one of the factors which was considered by the selection committee for the purpose of assessing the overall suitability of the respondent number 6, and it is on such assessment that the marks came to be awarded to the respondent number 6, placing him at serial number 1 on merits in the selection process. This court, in the facts and circumstances involved, also considering the nature of duties required to be discharged by a Ga Bura, does not find the approach of the selection committee in the matter to be erroneous in any manner. Accordingly, this on the set count also the challenge to the selection and appointment of the respondent number 6 would not be sustainable. Also, in view of the conclusions reached by this court herein above, this court is of the considered view that the challenge presented by the petitioner to the selection and appointment of the respondent number 6 would not mandate an acceptance, and accordingly, the present writ petition is held to be devoid of any merit, and consequently, the same stands dismissed. However, there would be no order as to what. IACP.
Much obliged, my lord.
IACP.
I took this.
But Mr. M.A. Sheikh, so the present interlocutory application has been instituted by the petitioner praying for amendment of the writ petition for the purpose of bringing on record contentions to the effect that the respondent authorities after the appointment of the respondent authorities after the appointment of the respondent number 6 as Ga Bura in pursuance to the advertisement dated 14/5/2018 had refused to furnish a copy of such appointment order to the respondent, to the petitioner herein. The prayer portion of the writ petition is also sought to be appointed, directing for praying for a appointed prayer of the petitioner. The prayer portion of the writ petition is also sought to be amended for incorporating a prayer It's the same thing basically, Mr. Sheikh.
Some chance is there.
Cosmetic. Which I've also made, a prayer has also been made. Amendment is also sought to be made in the prayer portion of the writ petition. So, this court has heard the learned counsel for the parties and also perused the materials available on record. On a perusal of the amendments sought to be made in the writ petition, this court finds that the said prayer for effecting such amendments was made in the present interlocutory application instituted on 12/10/2023, whereas the writ petition was so filed way back on 27/2/2015. Also, the factors that the contentions that are now sought to be introduced in the writ petition are contentions which were available to the petitioner at the time of filing of the writ petition. However, the same were not incorporated in the writ petition. Considering the nature of the amendment sought to be made, which in the considered view of this court is to the effect that the order of appointment of the petition was not furnished to the petition, to the order of appointment of the respondent number 6 as Ga Bura was not furnished to the petitioner. This court considers that the date of appointment of the respondent number 6 being available and as disclosed by the learned counsel for the respondent number 6, the said amendment would not be of no material, said amendment, even if not permitted to be carried out, would not materially affect the claim of the petitioner in the present writ petition. Also, with regard to the amendment sought in the prayer portion of the writ petition, this court, on a perusal of the prayer which is now sought to be so incorporated in the writ petition, finds that the same also only assails the appointment of the respondent number 6 with a further prayer for appointment of the petitioner herein against the post of Ga Bura of village Bodla Pothar. Also, the writ petition being also the prayer in the original prayer in the writ petition being also to the same effect, the denial of permission to the non-amendment of the prayer portion in terms of the prayer made in the present interlocutory application in the considered view of this court also would not cause any prejudice to the petitioner herein. Accordingly, considering the fact that the writ petition is pending since 2015, the prayers made in the interlocutory application, which is also found to be pending before since the year 2023, stands rejected. The writ petition would now be considered on its merits. Also, with the above observations and directions, the present interlocutory application stands dismissed.
Well,
That's
only one
rejected.
thing.
Obliged, my lord.
Your lordship mentioned as manual, land manual, but it is
Land
Assam-
regulation. Assam.
Land and Assam Regulation 1880.
I'll have to correct it. I'll do it.
Obliged, your lordship.
আৰামছে বাইদেউ এটা মাজতে এটা মই সেই বাউণ্ডেৰী কেছ তাৰ পৰা সেই 162 কপি কৰি
11 years হৈ গ'ল, 11 years of
এইটো কি
Pending
Mr. Day, you are for the State Bank.
My lord.
None appears for the petitioner. What is here left? Nothing. None appears for the petitioner on call. Mr. Day, take it, learn it. Standing counsel, State Bank of India appears for all the respondents. So it is seen that the petitioner on the last date that there was no representation on behalf of the petitioner on the last date of listing, that is on 10/2/2026. In view of the above position, this court is of the considered view that the petitioner has lost interest to pursue the present writ petition, and accordingly, the present writ petition stands dismissed for non-prosecution.
Hey, please, Lordship, kindly pass over matter time being, Lordship. Pass over the matter for the
Why?
time being, Lordship. If Fupon appears this case, Lordship,
Okay, we'll
his
hear
legs in another
petition.
court, Lordship.
We'll hear the petitioner in the meanwhile. Yes.
My lord, I'm appearing on behalf of my senior Mr. Ga Bura, my lord. My lord, may I plead, my lord? My lord, actually, we were seeking for enhancement and release of salary, which has been held up since January of 2015, my lord. My lord, what happened is that the petitioners, 5 in number, were daily wage workers who have been working since 2006 and 2008, my lord. And my lord, they had been receiving salary by cash prior to adjustment maintained and filed. My lord, if I may kindly, my lord, entire thing is based on
First,
Annex
Mr.
8.
Counsel,
Yes, my-
first thing, relax.
Yes, my lord.
Relax.
Every time I come.
Relax.
Yes, sir.
Just relax and make your submission.
Yes, my lord.
I'm here, I'm not interrupting you.
My
But I
lord,
want you
I
to
get a
do
little
this.
nervous at the beginning of
Don't.
this thing.
Don't get.
Yes, yes, my lord. My lord, if I
You
may
know, there
kindly.
is an Assamese saying,
Yes, sir.
Hati dat dekwa belek kwa belek. This
Yes.
court is also like that.
Yes, sir. Yes, my lord.
Be that.
Yes.
Don't worry. Be
Yes, my lord.
calm, have your breath, slowly tell me what is the matter.
Yes, my lord.
Hmm.
My lord, as I already mentioned that the 5 petitioners, their names were enlisted in the list which has been annexed as Annexure 7, my lord. But the original list, Annexure 6, their names were not there, which has been
Give me the page number.
my lord, my lord, first I would kindly like to direct you to Annexure number 8, my lord. My lord, here it says that the fine. May I read the order, my lord? The impugned letter. May I read the impugned letter? My lord, it says
Give me the
finance.
page number.
Page 66, my lord. My lord, it says finance department have no objection to enhance the remuneration to 59 numbers of engaged persons as at flag E, so and so, as per finance department's so and so. Further, finance department observes that list submitted wide flag E is for 64%, of which serial 60 to 64, that is 5 new names are included in the list which are not found in the original list as concurred earlier vide its endorsement so and so of file number 102 of 2005. The department is therefore directed to conduct a detailed inquiry into such apparently mischievous act of slipping the 5 new names, my lord. Now, my lord, if I may kindly direct your attention to Annexure 6, my lord. My lord, this was the original list, my lord, where the finance department had agreed to engage 72 number of grade 4 posts, my lord. Page number 61, my lord. As my lord, daily wage workers, my lord. Now, if my lord, if I may kindly direct you to page number 63, my lord. Page number 62, my lord. My lord, from 49, the last para, my lord, where peon is written, my lord. From 49 to 72, my lord. There are a couple of names, my lord. This was the original list, my lord. Now, if I may kindly direct.
Your name, is your name figuring? Your names are not figuring.
Yes, my lord. In the original name list, my name is not there. The 5 others, but also, my lord, 8 other people's name is also not there in the original list, my lord. My lord, if I may kindly direct your attention to page number 65, my lord, the subsequent list, my lord.
Just a moment. Relax.
Yes, yes.
You are hearing him. You sit. Whatever you have to say after he finishes. Yes. Where is the
Yes, my
next
lord.
list?
My lord, page number 65, my lord. The subsequent list, my lord. Now, my lord, here, my lord, I've
It starts
crossed
at page 64.
page 64, my lord, it begins from page number 64, my lord, annexure 7, my lord, the subsequent list, my lord. Now, my lord, if I may kindly direct your attention to page number 65, my lord, I've cross-checked the names, my lord, and it is not that only 5 people's name was not there in the original list. From 53 to, my lord, 59, who got the benefits of enhancement and the daily wage, their name is also not in the original list. And also, my lord, serial number 42, Shri Hiramoni Basumatari is also not there in the original list, my lord. These names are not in the original list. So stating that only 5 of the petitioners, my lord, who were left out, my lord,
So this is the list, basically 64 and 65 is the list.
is the subsequent
Which,
list, my lord.
which was considered
Yes,
by
my lord. It was,
by the finance
Yes,
in
my
its
lord.
UO at page 66.
Yes, my lord. Page number 65, I'm there. And my lord, in the original list, I do agree that the petitioners, the 5 petitioners' name is not there in the original list. But also, my lord,
Name
from
of another
53
8.
to 59, also their name is also not there in the original list. And my lord, all of this can be ascertained only if file number 102 of 2005 is presented before this court. And
Which
for
they have
11
not
years,
presented.
no, my lord, I do have the photocopy of that. But I cannot furnish it before this honorable court because it is not a certified copy. So therefore, my lord,
File
the
number?
matter is that, my lord,
File number?
file number 102 of 2005, my lord. I do
What is
have
the
the,
stand of the respondents in the affidavit?
my lord, in the affidavits, they have said that to one certain paragraphs which are common to both of them, they said that they do not have any further comments, my lord. And
Common to both of you means that 9 others.
yes, my lord. So, my lord, this is the matter in brief, my lord.
So are you working still?
Yes, my lord. We are still working, my lord, for 11 years, my lord. And this sort of employment is also mentioned in Article 23 of the Indian Constitution, forced labor and begar and things like that, my lord. That is also.
Are you given the minimum scale of pay?
No, my lord. Still not being
But
paid,
you
my
are
lord, for
being
11
paid.
years.
No.
I'm.
Are you getting us wages?
No, my lord.
No wages.
No wages also, my lord. To the best of my knowledge, as per the instructions of my senior, I'm not getting any kind of money, my lord, for 11 years, my lord.
But you are working.
Yes, my lord, in the hope that someday I will be getting the money back, my lord, in lump sum, hopefully. Only because of hope, the petitioner.
How long have you been in practice?
My lord, my lord, 1 year,
Good.
or something. My lord.
Yes, Mr.
Obliged, my lord.
Lordship, firstly, my lord, this matter is a 2015 matter, my lord. We have been newly appointed in this matter. We have been informed also, my lord, on the last occasion as per the last order. So, my lord, we were not served a brief also in this case, my lord. However, I have gone through the second copy of the case, my lord. If your lordship sees
Mr. Fukan,
the crux of the
Mr.
issue,
Fukan,
my lord.
while you make your submissions, please make it very consciously.
My lord, I'll make.
You're not appearing for the first time today.
My lord.
You're appearing from 2020.
My lord. The case has come after a long time, my lord. But we were not there. That is a different thing,
That is our fault.
my lord.
No,
I'm not blaming anybody, man. I'm not blaming anybody. I'm not blaming anybody, man. I'm just saying that we were not. There has been a change of guard in this
Now
case.
tell me why these people are not being paid.
The first thing, my lord, which I would like to point out is the impugn order. The impugn order which I have gone through from the second copy, my lord. The impugn order is annexure 8, which is dated 15/12/2014. Now, this particular annexure, if your lordship, comes to page 66, my lord. This is a particular notification which they have challenged, my lord. This is the main impugn order, if I'm not mistaken.
That is the order of the finance.
Exactly, exactly. So this is the impugn order, my lord. This is the, if your lordship sees, this is the impugn order. So the finance department, if your lordship sees, it's a sign, if your lordship comes to page 66, Commissioner and Secretary, SAD, and the sign is, my lord, first, if I may read, my finance department have no objection to enhance the remuneration to 59 numbers of engaged persons as at flag E, serial number 1 to 59 as per finance department's office memorandum dated so and so. Further, finance department observes that list submitted by flag E is for 64 persons, of which serial number 60 to 64, that is 5 new names are included in the list which are not found in the original list as concurred earlier by its endorsement dated so-and-so at page so-and-so of the file number so-and-so. The department is therefore directed to conduct a detailed inquiry into such apparently mischievous act of slipping the five new names in the proposal to submit action taken report within 1 month. SAD should they also digitize database along with so-and-so photo identity of each of such persons engaged by 31/12/2014 and submit action taken report by 31/1/15. Now, my lord, this particular order has been challenged, my lord. It has been issued by the Under Secretary Finance EC3 department. Now, your lordship comes to the cost title, my lord. Finance is not even a party in this case, my lord. They have not made a party.
We are ignoring that defect.
But my lord, their stand also has to be taken.
We are ignoring
But-
that defect.
But that,
But we take note
my
of the objection raised by the finance,
my lord.
which is that you have in your list incorporated subsequently 5 persons, that is the petitions, and then send it up for a enhancement thing. Finance says these people are not there in the original. The Learned Counsel for the petitioner has highlighted that, okay, we are not there. Further 8-9 persons who were not there in the first list have been incorporated in the second list. You have filed a affidavit. You have not dealt with that issue.
Lordship,
Where is that original file?
my lord, what I would like to take, my lord, in that case, my lord, in that other fact which your lordship has brought out, I would like to take instructions because I am appearing for the first time. If your lordship sees the
No.
orders,
You are appearing for the second time.
no, my lord. First time.
2000,
My
there
lord,
is another A. Fukan available
no, my lord, last
in the SAD department.
I saw, my lord, last date, my lord, my name has been
I think
sometime
which should not come to my eyes, normally come to my eyes. That's the problem.
last occasion, if you lordship, the last one.
Mr. A. Fukan, 21/3/2024. Learned Counsel for the respondent submits that they have been newly engaged to appear in the case and prays for 2 weeks' time to obtain instruction. Have you obtained? And who has not given you then?
My lord, in this case, we don't have a, my lord, brief
This
also.
court order is there. I'll not disbelieve my order.
Lord, some time may be given to me, my lord. I will have to obtain, my lord, because and plus, my lord, finance also is required, my lord.
Okay, you ask your secretary to hand over the file number SN 102/2005 part. I want it day after tomorrow. And if it is not there, your secretary will come online and explain the position. You inquire. Today I'm not troubling you. You inquire in your department. Where is that file? You note the file number from this last order. Did you? Mr. Fukan, we'll take up this matter after the break. Just have a talk. What has happened? And whether they are working.
Can I get a brief also, my lord? Because I'm
You
having
take
a second
second copy to Asani.
I'm using a second copy and I'm.
Oh, you give him the.
They have not
copy of
never
the
served us any
requisition.
copy also.
You.
Yeah,
They have not served us any copy.
How did you file an affidavit then?
I know that affidavit. Kindly see the date of the affidavit. Kindly see the date.
The petitioner is not there to go on serving copies to the replaced counsels.
My lord, it has been filed on.
That's not his duty.
The affidavit has been filed in 2015, my lord.
15 years.
My lord, I was not a counsel then.
That is not your headache. That is the brief ought to have been given to you by your department.
No, my lord, the petitioner, I mean.
Why should the petitioner give you?
There's been a change of guard, my lord.
Why? Have you given him a letter saying that, see, I am a new appointed counsel. Kindly give me the brief copy. Have you? No. He has done his work. You have filed an affidavit. How will he know that Mr. Fukan is without a brief?
No, my lord, 2015, this affidavit has been filed. Subsequent to that, my lord.
Better not to make all those submissions. Get the instruction where that file is, that last order it is reflected. And I ask them to trace it out. I want it on Thursday. But you tell me where the file is and what is the position. 2 things, Mr. Fukan. Whether they are working. Mr. Fukan, whether they are working as on date. Plus, show him the names of those other 9 persons. Just give it to him. Just convey it to your authorities. Let them give you that instructions. We'll have it on when?
Up to your lordship.
Thursday. Friday. But you, Mr. Fukan, for your convenience, please have a talk. Let me know by 2 what is the position so that I can modify my order.
I'll try my best.
2 o'clock. Come back at 2. And I'll not hear your senior anymore. I'll hear you only. Barbara, sir. Mr. Barbara, what are you waiting for?
From the other side, if it can be taken
Item
out,
number?
out of turn, item
Huh?
17, my lord, 6-year long penalty.
Oh, that recovery, 1 year.
Penalty is, my lord, straight, but I am losing promotion, my lord. Matter is very short, my lord. Other side is also here.
You're there. We'll hear it.
Yes. Please. My lord, the entire question for adjudication. I challenge the disciplinary proceeding. My lord, the questions for, I will not be shying away from the facts. Facts are good for me. But ultimately, everything will boil down to 3 things before your lordship. I have challenged the disciplinary proceeding as well as the penalty. No witness was examined.
And your case is that the inquiry officer had literally exonerated you.
Exonerated.
Can you take me to that inquiry officer?
Yes, my lord. Inquiry officer has literally exonerated. My lord, that your lordship will find at my lord, page 31. I will rely on Hardawal, my lord, Novokolita's case, Pradeep Koibotra's case, and then my lord, Punjab National Bank. That
1988.
his report at page
Punjab
31.
National Bank, 1988.
Yes, my lord. I will rely on my lord. Punjab National Bank, my lord, 1998.
98.
98.
This is the inquiry officer.
My lord, inquiry report is at page 31.
What is the final conclusion?
Well, before that, kindly have a look at the charge sheet. There were certain fraud committed for which some agents were, my lord, caught. They were charge sheeted and they were tried for a criminal case of fraudulently, my lord, changing documents. I was called there as a witness. Charge sheet is at page 26. That a policy which expired was again given a loan. They said the allegation is I pass, I am not the passing authority. There were also certain problems with the module which the presenting officer admitted.
Okay.
Then next page 27. Can this be an annexer? They have given 27 copy of the module generated loan payment. Yeah, I will come stated by presenting officer that the module was itself defective. NEP payment voucher, which I refused to sign. Then, my lord, copy submitted NEP mandate, my lord, charge of the name, the complainant Upendra Mahapatra. His policy expired long ago. Policy documents were never refunded by the office for 2 to 3 years. So, and then the next page, my lord, kindly see, page 28. They call it provisional list of witness. Any person conversant with the case.
Who was literally examined?
HOD.
No, in the inquiry proper.
Yes.
Who was the witness deposing?
No witness. Nobody, my lord, testified and my lord approved the document. HOD was the person against whom I made the allegations. But I brought it to your notice. I also requested you to make stop payment. You didn't do it. I refused to sign
So
the
now
voucher.
the inquiry, no witness was examined.
No.
The witness was, there was no list of witness.
No. Was a witness examined in the inquiry?
No. The inquiry report is before your lordship.
No. I just wanted a clarification.
No.
So there is
before going into the other things, this case is a case based on documentary evidence.
Yes.
Literally. No other thing is required. She signed some paper or she did not sign some paper, some policy which had expired had to be, she had approved, which led to the payment of the thing. How was the contents of those documents?
I am coming to the charge sheet. Second charge. That
You have passed the loan and all.
her authority is 50,000.
Okay, but how,
He,
if that is
after-
the thing, Mr. Nutt, if that is the thing, that a officer has a power of 50,000, she passed a loan of 1 lakh.
4,50,000.
4 lakh 50, anything above 50,000 is without jurisdiction.
Yes.
See, it did it. Now, you have alleged that against her. She files a reply, whatever it is, denial, non-denial, whatever it is. You are not satisfied. You go for an inquiry. Now, the inquiry, you can't just look at the document and say, the inquiry officer can't just look it in the document and say, oh, you have exceeded your jurisdiction, charge proved. Has to be established before him.
That is established.
How?
Kindly,
Who established?
kindly consider the inquiry report.
Mr. Barbara, 2 minutes.
Kindly consider.
Hmm.
Page 31, the inquiry report.
Hmm.
Then
What was it proved?
she was, the charge official was examined.
Hmm.
And the document was shown to her.
How can you will have to establish that first.
No. Whether you proceeded.
I see, let us hope that she said, yes, I signed it. Still, how is that charge proved?
That two aspect is there. Two aspect. Charge pass, two aspect are there. First of all, you cannot.
Rup Singh Negi is calling it.
Yes, 2007 9 SCC. My lord, Rup Singh Negi. I am coming to the two parts. First of all, that whether you have authority to touch this, considering it is a 4,50,000. That is one aspect. Second aspect, all the documents, and she admitted, and the inquiry officer also found that she did not tally the signature, the authority.
That is something not for the inquiry officer to find.
No,
It
she
is
is
something which was to be established.
she was given the opportunity that you, whether these documents is you
Sorry,
signed or
that
not.
is not the procedure.
That was not a third person signature, not
That
third
is
person's
not the
document.
procedure. That is not the procedure, mister.
Not because the third
Then
person,
why hold the inquiry?
third,
Your disciplinary authority will call her to the office. Hey,
No.
I have given you this. Have you done this? Yes, it is my signature. Okay, proved. Why inquiry? Why waste money?
and if I admit that it is my signature, then where
Where is
the
her
dispute?
admission? Where is her admission? Show me.
That I am showing. Page 32.
30?
Regular hearing. First regular hearing started on 11 a.m. on 8/6/2018. Charge sheeted employee does not have any objection to admit all the documents submitted by the presenting officer. He has exhibits from management side. Presenting officer was asked to submit some more documents in reference to a statement made in the preliminary hearing. Presenting officer submitted document P8 personal form. Senior financial power 23-page documents are handed over to the charge sheeted employee. Documents are provided to her, assisting employee for their examination. About complexity of the loan module, presenting officer stated that he personally checked the loan module which was in use at time in one of the city branch and verified. Charge sheet was asked, employee was asked, yes, why she did not cancel the payment voucher as mistakes regarding passing the payment was detected by her almost immediately. No third person is involved, only charge sheeted employee is involved. That is why she was examined.
Read now.
I, in her reply, charge sheeted employee stated that voucher generated through a single window cannot be cancelled at BO level, for which she requested HOD to contact DO.
So she has brought in a plea. She has brought in a plea with regard to that. How did you deal with
Yes.
the plea?
Presenting officer was requested to ascertain whether statement by charge sheet is correct or not.
This is the issue where you made the point.
Yes. Yes, charge sheet employee stated that she did not put her signature in the payment voucher. Therefore, PO was asked whether it is essential that all the employee involved in preparation, checking, passing required or put their signature in the payment voucher. Presenting officer stated that as per rule, corporation voucher is required to be signed by all. Second, first regularity. That is there. Second regular inquiry. Second regular hearing, that is there, could not be held. Charge sheet employee does not have any objection to admit 3 additional documents P8, P9, P10 submitted by presenting officer. Regular hearing. Stated that she did not notice that style of signature different in loan application. She did not notice. Loan debt voucher was mandate. She verified the signature but could not identify the difference. As she NEFT mandate stand validated, therefore she did not feel to go through it and its supporting documents. As stated by her charge sheet employee submitted the copy.
Sir, come to the findings.
Findings. Finding of the objection. During the inquiry proceeding, PO submitted 10 documents, that is document P1 to P10. Charge sheet employee submitted 1 document which was already submitted by the PO. Charge sheet employee does not have any objection to admit all the documents submitted by the PO.
Okay, let us deal
Then
with
I am
this.
coming to the yes,
Okay, let us deal with this one.
yes, but 6
The documents admission, no dispute. But the contents,
contents.
who proved it?
That is I am coming.
written, that is the document that was asked before her, because whether
Mister, she has given a clarification. I informed the DO. The PO was directed to verify, nothing thereafter. Who is the witness?
that is what is the charge? You pass the,
Whatever be the charge, you will have to establish it in the inquiry.
if I
Okay, got it.
my lord, that is what is the charge?
We are setting it aside.
Yes, lordship came in. It is, you had passed the policy loan statement payment. You have passed the vouchers against policy numbers without proper verification of loan application. That is the charge. Signature is not the issue. You did not verify documents. That is the charge.
Then why an inquiry? This can be done by your officer, your disciplinary authority.
That is the charge sheet. She used to say that yes, I verified. I did not verify.
It is not for her to say.
And
it is for her to deny and for you to establish.
That is another aspect. Another aspect. Beyond 50,000 you cannot. Why you proceeded beyond 50,000?
Then why a charge sheet is required, Mr. Does not?
That charge sheet was, but that is what her financial capacity. That is what I am saying.
Still old school in this connection.
My lord, page
Maybe
30,
the law has changed according to you.
page 30.
Show me a decision that this is permissible. Show me a decision.
On which point, my lord?
On this point that without the charges being established by the management, on the mere saying of the delinquent that yes, this is my signature and nothing beyond.
I am coming to page
The
30.
charge can be done.
That I understand. Lordship. That page 34, observation.
We got it. You show me.
Page 34, observation. While examining the signature, it is found that the signature are not at all together different. Many of the observations.
How did he come to that conclusion? Who is he to draw that conclusion? It has to be proved before him.
Charge sheet employee.
No, this is by the inquiry officer.
Because the inquiry officer, it is before the inquiry. Charge sheet employee. And then I'm coming to
No, you come to page 33. She did not notice the style of signature is different in loan application. That is her view. That, oh, this I did not notice. Now you come to the conclusion by the inquiry officer at page 34.
Considering the facts stated by charges as number charge sheet is disciplinary proceeding against the so-and-so also, charges are partly established, not totally exact.
No. Top portion. Page 34, observation.
Observation part. While examining the signature, it is found that the signature are not altogether different. Many
Alphabets
are same as that of the original. About the style of the signature, there is no set rule as to how signing
that is gone.
Moreover, the
As per
proposer,
the so-and-so pass.
LA proposer putting their signature, the words
Yes,
specified
in a
charge
place certain that
sheet
of the
template
claims
pass
and
the loan payment voucher without having requisite financial power.
Named victim. 6-2.
Where is your authority beyond 50,000?
Okay, come to the final, in my observation, that conclusion part,
Conclusion.
bold part.
Whole part. Considering the so-and-so, also charge sheet only personal statement recorded in the proceeding of hearing, in my observation, charges are partly established as mistake committed by her not due to not negligence. That is one. And nothing found during the inquiry proceeding to state that she knowingly acted in a manner detrimental to the interest of the corporation and prejudicial to good conduct. If PS Department of Branch Officer followed a rule regarding return of the policy bond, repayment of the policy loan, if voucher was done by the said fraudulent transaction would not have been taken place. This is the objection. Now
you come to the
disciplinary deferred.
Where is that disagreement note?
That is the show cause notice. That is also disagreed.
Okay, that is the disagreement.
Disagreement. He disagreed.
No personal hearing.
No,
Not required.
Not required.
Kunjam Bihari Misra, 97, 98, 97 SCC. Kunjam Bihari Misra. I have brought the judgment. Not required. Only this representation is required. She submitted against that. She submitted reply against that.
Okay.
She submitted.
But the fact remains that nothing was established by the management before the inquiry. Everything was on the presumption that she did it beyond her power without even a witness coming and saying that before the inquiry officer.
The third person is not employed here because she is the person who
that when the third person is not involved.
Because she charge is like that.
The following the procedure under
charge is like that. I am holding a chair. I am supposed to process a bill. If I commit a wrong, Then how third person is involved?
Fine, got it.
I committed wrong.
Any
And-
decision?
I committed wrong.
I got your point. I just wanted a clarification. We'll come back to you. Yes, Mr. Barbara, what are the decisions you want to rely upon?
My lord, in my reply to the search,
You have brought in a grade 4 employees story.
I clearly stated
That is.
that
good.
SOD, you give me this.
What are the decisions you want to rely, Mr. Barbara?
I, my lord, want to rely on non-examination of vital witness, the SOD himself. In my reply, I said that I immediately brought it to the notice. I am not the
That is recorded in the inquiry officer's report also.
report. Non-examination of vital witness. It vitiates the proceeding. Hardawari Lal, my lord. AIR 2000, Supreme Court, page 277.
AIR,
2000. My lord, I can supply a set.
you have given me a set.
Yes. Hardawari Lal,
Adjournment Lal,
page 2345.
AIR 2000. Supreme Court,
Yes.
27.
Non-examination of Virendra who was complainant in the
Para.
case. Yes.
Para,
Para, my lord, 2, 3, 4, 5, my lord.
next one.
Hardawari Lal. Then, my lord, the other case, your lordship happened to be this side. That was my lord judgment.
Can I
by
consider this?
No, Kanta Kolida. No, this is law. This is law, no question.
My Lord Justice Bhuya's order.
Yes,
Ah.
yes. It is, here it was discussed, my lord. Here Hardawari Lal was discussed. Failure of the authority to examine head constable Jasbir was witness. Departmental inquiry had clearly vitiated. It is a law. Your lordship will have to take into account. Forget about whether some 7 years ago your lordship was in the other side. It is law by our High Court. And it, my lord, it banked on, my lord, Supreme Court decision. It cannot ignore. Number 27. Each article of charge must be supported by a statement of the imputation of misconduct behavior, including a list of documents. This is not there.
Okay, we got
Only the charge sheet. No statement of imputations in this case.
the next
I
one.
have shown the election. Next case is, my lord, Pradip Koibotto, failure to produce witness, 2015 for DLR Diasana, 616, paragraph 32, 33, 34. Failure to produce witness. Here only one witness, ace of the department. And their list said that provisional witness, any witness we can summon. Can that be a, my lord, charge sheet and my lord, list of documents and list of witness in the eye of law?
Oh, Mr. Barbara, okay, let us see, they did it.
And then Rup Singh.
But they want to introduce a witness, they can still do it
Yeah.
by giving you a notice of that.
Give it.
There is no bar.
There is not. Then my lord, Pradip Koibotto, 2015, volume 4, at GLR. 616, failure to produce witness, violates national justice.
Yeah, we have got.
Then, my lord, Punjab
Punjab, yeah.
National Bank, 1998, volume 7, SCC 84. Yes, sir. Here, Anna, that Kilagusha.
Why are you relying on Kunja Bihari?
My lord, I am coming. Yoginath, my lord, AR 199, Supreme Court. It said, my lord, about even disciplinary authority differed from that. Hearing is a must anyway. And witness must produce documents.
No, Kunja
Rup Singh.
Bihari is for the proposition that when the difference is there, a reason, but that I think they have done it.
Personal
So
case.
this may
My
not
lord,
be.
even-
And what is this?
I am just citing.
Yoginath D. Bhagde?
Then Rup Singh Negi.
So Yoginath D. Bhagde for what proposition?
Yoginath, my lord, where the court said, my lord, when the disciplinary authority differs with the inquiry report, personal hearing is required.
Kunjari Bihari Mr. relied in Baje. Kunjo Bihari Mr. relied in Baje.
So I can read that paragraph, but it is not enough if you give a no.
No, but it depends on the rules, but the general proposition is that he has to, along with the inquiry report, forward his disagreement note so you can give a consolidated representation against both. And that is, I think, enough for the purpose of natural justice, right, Mr. Nath?
Yes.
But there is no material discussion.
Okay, Rup Singh Negi.
Then Rup
the
Singh
proposition that
Negi,
documents.
the documents must be proved. Merely placing a bunch of documents will not do. That is no inquiry in the eye of law.
The
No.
contents not
Yes.
proved.
Somebody will have to be there that, yes, Document number 3, this, content is this.
Anything more, Mr. Bora?
Then one more thing, no, that's all. So I am deprived of promotion for last 5 years for the disciplinary proceeding, my lord. Prayer is to set aside the proceeding, set aside the impugn order of penalty, including the appellate order. That's all.
Mr. Nath, what is?
My lord,
the-
I am submitting the minutes of the inquiry proceeding. Yeah, that here, my lord, I am just pointing out, I highlighted. Do you have any document or witness for defense side? Support of your presentation, yes.
My requisition is not
Please,
necessary.
please submit it, what is in the inquiry, my duty is to. Please submit the documentary evidence also.
You have the
listed with
proceeding sheet.
Yeah,
You have the
Yes.
daily proceeding sheet.
yes, yes. Minutes of those.
So High Court said it is the bounden duty of the prosecution to bring. My requisition is not necessary. Whether I requisition somebody.
Because that is her contention. That someone dictated her. Or some officer requested. That is not the contention of the prosecution side.
Where does it start?
There is the contention of the defense side. So defense side should
So
brought her.
tangled up, like your inquiry.
My lord,
I don't get the first page.
first page, my lord, sorry, that's highlighted. Yes.
Now. This is the report.
Page কিমান দেখাইছা?
কোনটো? নহয় মই মাইনৰটো দিছো এটাই কপি মোৰ লগতো নাই পাহৰি গৈছো ৰেকৰ্ডৰ মাইনৰটো
Yes, Mr. Nath, what are you trying to rely upon?
My lord, on this, my submission is that I am not relying on the authority. My submission that principle of natural justice is followed, and she was provided proper opportunity from the departmental proceeding records. Lordship is sending. And
Just find out the admission of the petitioner that she had passed the loan above her capacity. That specific question and the admission. The second charge that she passed the loan, a question to her that you passed this loan beyond your capacity. If you find it, just mark it for me. But Mr. A.C. Barbara, learned counsel for the petitioner, learned senior counsel, assisted by Ms. N.D., learned counsel appearing for the petitioner. Also heard Mr. S. Nath, learned counsel appearing for the State Bank of India. That is the learned standing counsel, State Bank of India appearing for standing counsel, Life Insurance Corporation of India appearing for all the respondents. Hearing concluded, registered to list this matter khali date 6/4/2026 for delivery of judgment.
6th April.
I'll deliver, that's all. You just mark that portion wherein
Yes.
that she has been asked. That much only.
Yes.
And you give it back to her.
Yeah, I have not seen that.
It is not for your eyes.
Obliged, Lordship.
Okay, please, your lordship.
One minute. Yes. There are two writ petitions. You are for the petitioner in both.
Lordship.
And in the both the writ petitions, the selection and appointment of Pushpalata Dole is in
Lordship.
challenge.
Lordship.
Yes.
Lordship, after long gap of communication gap, I could contact with my client day before yesterday. Luckily, my colleague is from that area. She could collect the phone number. And now, after talking to my client in item number 5, Meena Kumari Dole, she told me over telephone that some subsequent development has been happened, Lordship.
What is that subsequent development?
Lordship, actually, in the impune observation, in compliance with the court's order, Lordship, but a departmental observation.
Where?
Lordship, Annexure 6, page 23. In these observations,
Where observation? Which is the relevant portion?
Lordship, in this observation, there is not a single word against my appointment. But Lordship, kindly come to the next page, 24. 1, 2. Paragraph 3, Lordship.
Report reveals that.
Lordship. Report reveals that the residence of respondent number 8, Srimati Nirumai Pegudole, is within the concerned number 117 Kekuri Dadabari AWC area. Hence, the claim of the petitioner, number 2, Srimati Jyoti Kottum Pegu, could not be considered.
Jyoti, we are not here. Jyoti is not here before us.
Yes, Lordship.
Nirumai Pegu Dole is not before us.
Yes, Lordship. Lordship, just to adjust Nirumai Dole Pegu,
is there a projection to that effect in the writ petition? No.
Lordship, no.
Is Nirumai Dole a respondent?
No, Lordship, just she was appointed in my place. Therefore, my appointment was cancelled.
Who? Nirumai?
Yes,
But you have not even made a party.
yes, Lordship. But yesterday I came to know that Nirumai Dolepegu has died, Lordship.
Maybe that will be put up for fresh recruitment. If you are within the age limit, you will apply.
Lordship, it was a very short telephonic communication, Lordship.
I can't help it because in the writ petition is not projected in that lines.
Lordship, if necessary, I will.
We will not permit you to amend the writ petition after 10 years.
Yes, Lordship.
Because that is a fact which was there.
Lordship, in the my submission.
So you have got no grievance against Pushpalata Dole Gopegu.
Yes, Lordship.
Who is appearing for Pushpalata? Where are you appointed now? You also don't know.
Yes, 2014.
Huh?
31-10-14.
Where? Page? Appointed where?
In my additional affidavit, page 33.
In item number?
Of the order of this honorable court.
Item number?
Item number 5.
Bina Kumari Pegu. Additional affidavit.
Pushpalata Dole Pegu. In my affidavit.
Oh, in your affidavit?
Yes.
33. Page number?
33.
Where is your appointment order?
Page 33 is my appointment order.
After the order of this court, okay.
Yes.
In pursuance of the director so and so, in respect of so and so, he is hereby engaged as so, madam, it is Pushpalata Dole who was engaged, not
Yes, Lordship.
not
Sure.
not Nirumai Pegu Dole.
Yes, Lordship.
Then-
But her place of appointment is not my.
Actually, she has no given secretary.
Kekuri Dadabari Anganwadi Center and
Kekuri
Nirumai was also
Dadabari. Now, my instruction is she is.
withdraw it. If you say that you have no grievance against Pushpalata Dole, we'll record it and we'll dismiss the writ petition.
Chief, that's why, because it was my yesterday only telephonic
Sorry,
instruction.
no adjournment.
Lordship,
On that count, it's no adjournment. It's no ground at all.
I understand, Lordship.
But we also got to record something. We can't record absurd things in our orders.
Lordship,
What do you have to say about your challenge to Pushpadala Lata Dole Pegu
Lordship,
as Anganwadi worker, Kekuri Dadabari Anganwadi Center?
Lordship, I made them party respondent.
Who?
The private respondents. Because of their case, the observation was made. After the
This observation is of no use now because it is, you show me how you have to be appointed in place of Pushpalata Dole Pegu. That's all. We'll appoint you.
Yes, Lordship, my appointment has been cancelled without any remark or
Show me,
observation.
madam. Where is your appointment? Show me that.
Lordship. Lordship, my appointment order is in my writ petition, page 22, Annex 5. Order dated 3/4/13, Lordship. In pursuance of government order number so and so, and approved by the state level screening committee of Anganwadi workers, helpers, and Anganwadi workers Dispur, Srimati Meena Kumari Pegu, care of so and so, village Kekuri Dadabari. District Lakhimpur is hereby engaged as Anganwadi worker and mini Anganwadi worker at Kekuri Dadabari with monthly honorarium of rupees 3,000 per month. The engagement is purely temporary and subject to be terminated without assigning any reason thereof. She is directed to submit her joining report to the undersigned within 3 days after receiving this engagement letter. Lordship, thereafter, because of that case, Lordship, where I was not made, a case filed by the private respondent, where I was not made party, Lordship. In one case, and other case, although I was made party, later on, requisition was withdrawn. In compliance of the Honorable Court's order, Department have passed an order, Lordship. That is the next page, Annexure 6, page 23, Lordship. Order dated 11 September 2014.
Where is this order? 29/11/2012, not on record.
Yes, please, page number 16,
Of the petition.
repetition.
Yes, Lordship.
But madam, what is your stand? Come to page 24. Right?
Lordship.
Second paragraph, last line.
The child development project officer is hereby directed to cancel the engagement of Junali Kaman as Anganwadi worker in 117 Kekuri Dadabari AWC, Lordship.
What have you said? But it is, so you are projecting that it was you who was appointed.
Lordship.
And the order says one Junali Kaman was appointed. What is your stand
Chief,
in the writ petition?
my simple submission is that, Lordship.
No, I want that stand. What is your stand with regard to, you have challenged this impugned order.
Lordship.
So what is your stand with the second paragraph of page 24, last line?
Chief, my submission is that at para 11, page 9 of my writ petition, although there was not any para 11, page 9 of my writ petition, Lordship. Petitioner
I'm
submit.
sorry, we are not worried about that. I want a specific stand of yours with regard to that second line. Second paragraph, last line.
Lordship.
Because that is you are challenging.
Lordship.
That is a finding against you. How have you dealt with that?
Lordship, then Lordship, thereafter, report reveals that the next paragraph, Lordship, same page 24, same Anganwadi worker, Lordship, 117, that one Nirumai Pegudole was within the concern, same Kekuri Dadabari, Lordship.
I got your answer. I got my answer. Anything more?
That's
The
right,
answer is apparent. Come to page 28, last line. Para 10.
page
28 of the affidavit. Internal page 3. I missed to mark it. That was I was searching yesterday. I missed to put a, what do you call that, a tag there.
affidavit, Lordship, who is affidavit?
Affidavit by Vipul Kumar Das,
Lordship.
CDPO, I suppose. Circle officer.
Paragraph 5, Lordship. That with regard to the statement made in paragraph 5 of the writ petition, the deponent begs to state that in the minutes of state level committee held on 10/1/2013 regarding engagement of AWS under Dhokwakhana ICDS project, the name of the petitioner was recommended for engagement subject to fulfillment of other criteria. It was
Para 5. Come to para 10.
With regard to the statements made in paragraph 13 of the deponent begs to state that as per comparative statement of the interview of candidates of 3,472, Kekuri Dadabari, Sri Meena Pegu was placed in the third position. The first and second candidates were found outsider. Meena Kumari Pegu, writ petitioner, was engaged AWW of Kekuri Dadabari by order dated 3/4/2013. However, later the Director of Social Welfare, Government of Assam, is in order to number so dated 11/9/2014 found Puspalata Dolepegu within the concerned AWC and considered for the post of AWW in
Accordingly, your appointment was cancelled. Engagement was cancelled on 30/10/2014. Right? And then that lady was appointed. And you come to your reply.
Lordship, my reply is
Para 6.
para 6. That with regard to the statements made in para 7, 8, and 10 of the affidavit, the deponent begs to state that she vehemently opposed the statement made by respondent number 5, that the order dated 11/9/2014 passed by the respondent number 2 by memo number so never speaks about my irregularities, anomalies with regard to the writ petitioner deponent. The said order was passed on the basis of order dated 29/11/2012 passed in WPC number 4205/2011 by the Honorable Court, wherein the writ petitioner was not made party. Therefore, she was not directed by the respondent number 2 to appear before him or never issued any notice to the writ petitioner while conducting the hearing on 11/9/2014 held in his office. It may be pertinent to mention that a writ petition was filed wherein she was included as party being WPC number 3408/2013, which was later on withdrawn by the petitioner. As such, there was no observation in respect of illegalities with regard to the service of the petitioner deponent in order dated 11/9/2014 issued by the respondent number 2. In such a situation, the impugned order dated 30/10/2014 issued by the respondent number 4 is illegal.
But you have not dealt with the statement that you were placed at serial number 3.
Lordship, give me
We'll
one.
give it a quietus.
Lordship, I have to prepare. Lordship, it's tomorrow also,
No,
Lordship,
no, no.
tomorrow.
Today.
So that
2 o'clock.
tomorrow, Lordship,
No, no.
Lordship.
We have invested much time. 15 matters will not cross the day today. Yes, what is your grip, your case?
She has no given against me.
Huh?
She has no given against me. My appointment.
You are appearing for
6 and 7.
6 and 7.
2 minutes.
Pushpalata Dole was appointed.
Yes, yes.
Then there was no challenge to your appointment in the present order writ petition.
No, because the private respondents are
Yes,
appointed
she is
by-
challenging her cancellation order. Moment her cancellation order goes, we interfere, your appointment will go.
Lordship, Social Welfare Department has not filed their affidavit, Lordship. Lordship, their affidavit is necessary.
They will file it in the fresh appeal that you will file. The appellate proceedings.
Without their affidavit, I am also helpless.
That they will file when you file an appeal against my order. I'm giving you time till 2 o'clock.
Lordship.
দুটা বজাত প্ৰথম item এটো মানে।
Obliged, Lordship.
Mr. Deka, your matter. Junior instructor to senior instructor.
Yes, but there are three conditions of promotion. Junior instructor is a base post. And for junior instructor to they get promotion to the post of senior instructor. Thereafter, they get the promotion from senior instructor to supervisor. And then from supervisor to senior supervisor. In the instant case, my lord, the petitioner was appointed to the post of junior instructor. After completion of more than 17 years. Now, there are three conditions of promotions. Number one, there is a verdict or order of this Honorable High Court Division Bench that after completion of 10 years of continuous service, there is a provision for automatic promotion. They get automatic promotion after completion of 10 years. On the other hand, another condition is as per service rule that 100% of the post of instructor shall be filled up by promotion of the junior instructor. Under these two conditions, 5 numbers of the respondents were given promotion to the post of instructor after completion of their 10 years. When they are promoted at the age of arriving of 10 years, the petitioner continued services for more than 12 years, some months. But his name is left. Why his name is left? There is no any explanation because
Only thing they have said that some working was not found proper. That cannot be a ground.
My lord,
There was no proceeding against you at that point of time. There was no proceeding against you at that point.
there's no proceeding, no any adverse comment. Actually, my lord, had there any proceeding to, there is a provisions for consideration of his promotion and maybe kept under.
Where is that order promoting the 5 people? It's,
He has clear service, no any.
no. Where is that order promoting the 5 people?
Yes, my lord, I am.
Page.
My senior have to file the reply affidavit, my lord.
He is not filing it. Page 87. Mr. Decca, page 87, 86 order. That 5 people promoted.
Yes, my lord.
Where is that order?
I am here. I am here.
Slowly.
Promotion order is at, my lord,
Page 35.
here 33. 33 or 33?
35.
The fair copy is in 30.
When did you retire?
Fair copy is 33 and
Mr. Decca, when did you retire?
the date of retirement was
31st
17. 31st
August
August 17.
2017.
Okay. What is your grievance now? What is your relief you want?
The petitioner needs to be promoted.
These 5
Already
persons who
proposed-
have been promoted were juniors to you.
Yes, my lord. From the with respect to the
And from the same trade. Your trade was junior instructor in which trade?
from junior instructor.
No. You are junior instructor in which trade? Electrical, mechanical, what are you?
To my lord. But they are qualified. I am not ending the subject, but they
Okay,
are equally at the same list or promoted. His appointment order also was in the same order. The qualification required was similar, identical.
And civil.
Yes, what is the relief you want?
So my prayer is that the petitioner may be promoted to the post of senior instructor with retrospective effect, and subsequently the promotions to the post of senior instructor, then supervisor and senior supervisor. There are the provisions of rule of Canada. The government of Assam has promoted some persons in the secretary also who were retired but left for promotion, and their promotion was made after their retirement with retrospective effect. And we are far.
When was those promotions made in the secretariat? You can tell me the date.
And there are provisions also for a promotion for the purpose of financial benefit, my lord.
What?
Financial benefit, salary benefit, pension benefit, etc. My FR 5A.
FR 5A.
FR 5A. The state government may relax the promotion provisions of rules or order so made by it in such manner as may appear to it to be just and equitable. Relaxation of normal FR 70 method. There is the provisions for promotion with retrospective effect.
Where is that provision? There is no provision.
Yes, sir.
That says that the government has the power to relax.
Yes, my lord.
But there is no provision that you can be promoted with retrospective.
But my lord, the order of the government must be equitable, my lord. There cannot be a disparity. When I was fit for promotion, I have no any adverse comment against my service
So
career.
your promotion grievance starts from 1993.
Yes, my lord. Why I am left at that time? When my juniors, 5 numbers of juniors have been promoted in the same provisions of completion of 10 years, then why I am left? There should be an explanation. There should be a disqualification.
Mr. Deka, accept it. Your grievance starts in 1993.
Yes, my lord.
We'll have to determine your right as of 1993. I have 2 issues, 2 queries. 1, why the delay from 1993 to 2015 in assailing that? 1. Because there is apparent a delay of around 12 years, which is fatal. 2, you have admittedly retired on 31/8/2017. It is a settled law now after the decision of the Honorable Supreme Court in Dr. Amal Satpathy, Calcutta case, that you cannot be promoted with a retrospective effect after your retirement. So these 2 points will go against you. What do you have to say?
But the government of Assam have given promotion up in 2019, my lord.
That is an illegality.
2019 government have promoted more than 120 undersecretaries.
That is in 2019.
Yes, 2019.
But now the decision is of 2025, Supreme Court. Latest. So we cannot promote you because Supreme Court said that on your retirement, you cease to be an employee. Then how can you assume the charge of the post of senior instructor or supervisor? Because it's not possible for you to assume that charge of that post. So it was not given. Amal Satpathy.
The problem is that on the date of promotion of the private respondents, I was 100% qualified.
I know. We have.
But I am left. It is discrimination of law also. This is a discrimination of violation of.
But that discrimination by your conduct turned it into laches because you did not immediately come up before this court.
Not my lord. It is not my conduct because of my conduct, because I submitted numbers of representations.
Representation.
Yes, justice, everybody should come to the court He cannot be possible because he may not be in a position to come to the court. So in every grievance, we shall go to the court.
Okay, have you
Next day I
explained
shall
have you explained the delay in your writ petition? Have you explained the delay in your writ petition? No,
I did. I said that this is not, there is specifically not mentioned.
it was not given. Okay, Mr.
But the
Deck.
procedure, the method, procedure has continued.
Yes.
Procedure has continued.
Yes, Mr.
My action was continued.
Mr. Decker, please have your seat. Yes.
Not, we have given the petition the ACPS.
It is nothing.
But if he is not
But
promoted,
why was he not promoted?
he has left out. As per this affidavit, his name was not proposed by the superintendent
That is
at that point
an
of time.
error. There was no proceeding against him.
Yes, madam. There
He
is no
should have
proceeding.
been promoted.
Yes, madam. He should have been promoted, but
So he has been given ACPS benefit.
ACPS benefit has been given, madam.
So 2 posts. So at least till supervisor he has got.
Twice he has been given. One on-
Grade pay or pay band.
Generally, it's
Grade pay.
great pay.
Something like greatly India some benefit
Mr. Decker, ACPS benefit is great pay.
No,
Only some increment.
some 200, some says.
Yes, madam. Something like that.
Now tell me, there is an order of this court of 2000 which says that automatic upgradation on completion of
Yes,
payment.
ma'am. That was before framing of the rule. Our rule came in force on 1993. After coming up the rule, that exhaust, my lord.
So he was denied of
No,
that
my lord,
benefit.
my lord, there are
He
two
came
provisions.
before this court before his retirement.
Yes, my lord.
So he's still entitled to that benefit. We'll have to give him that.
My lord, the 10 years autonomous service was judgment order of this Honorable High Court, and also report of the Pay Commission and order of Finance Department
For what?
that there is 10 years automatic promotion is not the order of only
My lord,
government, but it was recommended by the Pay Commission.
Mr. Decker, please have a seat. Please have a seat. You have a seat, please. Yes.
para 10 of our affidavit, my lord, we have said that sub promotion process was made in 1993. Before the act, the rule was in force.
The rule was not covering.
No,
Rule came subsequently.
yes, my lord. Rule do not cover his my lord, cadre.
Why?
There is a dispute, my lord, if your lordship remember, our lordship has also given a judgment recently. That instructor word is not in the rule.
But that is why he is not being promoted.
No, that is not the reason here, my lord. This is different. This is, my lord, before prior coming of the force of the rule.
So then the High
10
Court
years,
order will
10 years.
hold it till 10 years.
Yes, my lord.
So he should be promoted as supervisor.
Yes, my lord.
We are not giving him any, will not give him any, what do you call that, monetary benefits.
My lord.
But his pension and pensionary benefit should be revised.
But if your lordship kindly peruse, my lord, in paragraph 6, my lord, he has been granted the ACPS benefits.
ACPS is nothing.
But that is when a my lord, employee is denied of any promotion, my lord, so my lord, this benefit is given.
ACPS is nothing.
As per the OM, my lord, we have given this ACPS.
But here, his fundamental right for consideration has been denied to him.
My lord. That's admitted, my lord. He should have approached the department earlier, my lord, before approaching the court. He have also not approached the department also. You are sitting idle, my lord.
Okay, Mr. Decker, where is your representations?
Madam, there was rule of service for 1993. At that time, service was there. And that service rule, the promotion process is mentioned, my lord.
Okay, where is your 93 you were deprived? Where is your representation immediately after 93?
There is one in page 96, Another 97.
Page 96.
Yes, ma'am. With forwarding of application, it was forwarded by senior principal.
Oh, don't
He has
click
forwarded
on the-
95. after 90.
This is of 12/1/2016.
Not translated,
No, no.
Huh?
not translated.
No, correction.
Translated. Page 93 is the translation.
93, my lord. From translated.
But this is of 2016, 93.
That one, my lord.
Yes, 12/5/2016.
Got it. But
Right.
your grievance is 93.
Earlier applications are not enclosed, my lord, here. Because those are very old and
Where is your statement to that effect? In the writ petition?
I have not mentioned this, but only I have mentioned that I have submitted numbers of representations and waiting for the decisions. But no decisions came from the end of this authority concern. Matter as continuance.
Okay. Heard Mr. C. Deca, learned counsel for the petition. Also heard Mr. S. V. Deca, learned counsel. What is
Not
the
for,
department?
not skill, employment and entrepreneurship.
Skill, employment and entrepreneurship appearing for the respondents. Number
3 and
1,
4.
3, 4. Hearing concluded. Registry to list this matter again for judgment. Short date there. Subjects aase nahi bale. 26 for delivery for this. We'll pass the order on 26th. May go against you, can't help it. May. Let me see.
Oblations.
If that may on 26 may also be, I may be also allowed to give some supplementary.
Welcome, most welcome.
Oblations.
Wait, please, Your Lordship. As per the order dated 23/11/2021, the respondent number 4 was required to obtain instruction in the matter regarding regularizing the service of the petitioners.
Yes, Mr. Chalia, any information?
Lordship, there was a statement made that Finance Department had actually rejected the claim of the petitioner. Here, the petitioners were employed under particular schemes. Now, the case of the petitioner is that similarly, some of the employees, their services were required to be considered to be regular for consideration. Now, here the department was, the authorities in the PNRD stated that Finance Department has rejected the claim of those petitioners. So, on the last date, Lordship, I had requested to give me a copy of the rejection whereby when we were approached if we had actually rejected, Lordship. That has not been given. We have the copy of the writ petition, but Lordship, we do not have the record of the rejection. And they were employed under a scheme.
PRDA,
Yes.
you're working still?
We have to take instruction in the matter. We have lost contact actually. Your
Lordship, yes. 21 it came on the last, Lordship. Now, the authorities in the PNRD also.
They're continuing.
I don't have it.
You get your instruction by 2 o'clock, whether they are continuing. Oh, you ask your authorities to give you instruction whether they are continuing in their service as on date. That much only.
Lord, the petitioner was willing to engage some other advocates and I have given them an NOC.
You don't appear. I'm dismissing you.
Thank you.
The file has been taken away from you. Mr. Deca, file has been taken away from you.
Right.
When?
It may be months ago.
Months ago. So you are not appeared today. None appears for the petitioner on call. There is also no representation on behalf of the respondent. The writ petitions accordingly stand dismissed for non-prosecution. Should I dismiss quickly? Very good. The writ petitions. Very good. Go for the bank.
Back, my lord.
He was dismissed
Dismiss, my
way back in 2003
lord.
or 4.
Oh, my lord. Then, my lord, after
Appeal. Then review, all dismissed.
all dismissed.
2004. He has not approached this court. In 2016, the criminal case, he has been acquitted, right? After 12 years of service. Benefit of doubt.
Benefit.
Benefit of doubt. And then he filed a review before you. You rejected it, rightly so. None appears for the petition on top. Not dismiss it on merit. They come, they will see. Cite up on solicitor sign. File it. None appears for the petition on call. Miss
PK Bura,
Ga Bura, B-A-R-O-H or A-U-H,
WOAH.
W-A-H, is present for the respondents. So in view of the above, registry, in view of the above, the present petition stands dismissed for non-prosecution.
My lord, item 18, my lord, I may be allowed to withdraw, my lord. Actually, my lord, it was regarding all recruitment, my lord. In the meantime, my lord, the petitioner already got employed in some other department.
No, 18 too. There was an application submitted for adjournment today.
Yes, my lord, learned advocate of the state government, my lord. He's not well, but
So, don't go on.
Mr. On behalf of Mr. Kumar, my lord, adjournment was sought.
Mr. G.
But my lord, since the petitioner already got employed, my lord, so he wants to withdraw.
Otherwise, also, how is this writ petition maintainable? You have challenged a selection process.
Yeah, my lord.
Where are those selectees? People were appointed against that. They are not here. How do you expect
No.
this court to? No. You have not implemented them as
Oh,
party.
yes, my lord.
Joseph, I'm for the respondent number.
Yes, Mr. Gore, GC Gore, learned counsel for the petitioner, on instruction submit that the petitioner desires not to press the present writ petition any further. And accordingly, he prays that he be permitted to withdraw the present writ petition. So, Miss
H. Devi.
H. Devi, learned counsel appearing for,
J.I. Borbhuyan. J.I. Borbhuyan.
he is for,
Respondent number 678.
J. Borbia, learned counsel appearing on behalf of Mr. J. Borbia, learned counsel appearing for the private respondents. Number
78.
78. Also, in view of the above, the present writ petition stand for non-prosecution.
Okay.
Finding is in. Oh.
Please, Your Lordship.
Hmm.
Uh, Lordship, kindly again come to the report, Lordship, an exercise, page 23 of my writ petition, Lordship. In the first paragraph, Lordship, may I read the report, Lordship? May I read the report, Lordship?
Yes.
Peruse the Honorable Gauhati High Court order dated so-and-so, passed in WPC number so-and-so, in the matter of Torujuti Dolepegu and two others versus State of Assam. Petitioner number 1, Srimati Torujuti Dolepegu, applied for the post of Anganwadi helper in 96 Uttar Dadabari AWC. Petitioner number 2, Srimati Juti Kutumpegu, applied for the post of Anganwadi helper in 117 Kekuri Dadabari AWC, and the petitioner number 3, Srimati Puspalata Dolepegu, applied for the Anganwadi worker in 117 Kekuri Dadabari AWC under Dhokwakhana IPDS project, Lakhimpur. The petitioners have claimed that on receipt of a complaint, they are not resident within the concerned Anganwadi center area. They were deprived of getting engagement as Anganwadi worker helpers. They submitted representation before the Deputy Commissioner Lakhimpur for re-investigation of their residential status, but no decision was taken up. The Honorable Court directed the Director of Social Welfare Assam to examine the grievance of the petitioner and to pass consequential order thereof. This directorate have received a report from the Deputy Commissioner Lakhimpur by letter number so-and-so dated 30/4/2013 regarding residential status of some of the respondents. The said report was submitted in response to government letter number so-and-so dated 21/6/2012. The report reveals that respondent number 9, Srimati Junali Kaman, is staying with her husband, Sri Sanjeev Pegu, at Kathalguri Village under Kadam Revenue Circle since 2008. The report reveals that the name of the husband of the respondent number 7, Ganita Pegu, is not Rajiv Dole. The actual name of her husband is Siri Manoranjan Sinte, who is a resident of Chumoni Medak village under Chubanshiri Revenue Circle. The report also reveals that the Lal Gabuha of Kekuri Pomua, Siri Rama Dole, has submitted a petition before the Additional Deputy Commissioner Lakhimpur, clarifying that his earlier certificate issued regarding residential status of Ganita Pegu and Junali Kaman was wrongly recorded. This directorate requested the Deputy Commissioner Lakhimpur to submit another report regarding residential status of respondent number 8, Srimati Nirumai Pegu Dole, and all the 3 petitioners by letter number so-and-so dated 5/6/2013 and letter number so-and-so dated 28/2013. Accordingly, the Deputy Commissioner Lakhimpur submitted report by letter number so-and-so dated 1/2/2014. Report reveals that the resident of Srimati Nirumai Dolepegu is at Kekuri Dadabari Gaon, where I was appointed, Lordship. As per the report of the residence of Srimati Torujuti Dolepegu is Uttar Dadabari Gaon. Residence of respondent number 2, Srimati Juti Kaman Pegu, is Pasim Dadabari Gaon, and the residence of the petitioner number 3, Puspalata Dolepegu, who is the respondent, Puspalata, is also Kekuri Dadabari Gaon, Lordship. Thereafter, the next page, Lordship, third paragraph. Lordship, got it? Report reveals that the residence of the respondent number 8, Srimati Nirumai Dolepegu, is within the 117 Kekuri Dadabari area. Hence, the claim of the petitioner, Srimati Jyoti Kutum Pegu, could not be considered. So, my humble submission is...
Jyoti Kutum Pegu was a helper, not a Anganwadi worker.
My humble submission is, Lordship, that there was not a single remarks or report that I am not the resident of...
No need, because you were appointed, because 1 and 2, which includes Puspalata Dole, was found to be beyond the Anganwadi center area. Now, when they are brought in, your appointment was cancelled, which you came up challenging before this court. Where have you stated materials that, see, the finding of the director that Puspalata Dole is not a resident is false. It's perverse.
Lordship, two persons are from the revealed, two persons are from the same Anganwadi, Nirumai Dolepegu and Puspa Dolepegu.
Niruma is gone. And the next case,
Lordship,
Ghanita Pegu.
Lordship. Lordship, in the next case, I have no instruction whether the petitioner is willing to pursue.
We'll consider it on merit. Don't worry.
Lordship.
Anything more? Yes.
That,
You are working since?
yes, my appointment, on the sum was 6 and 7 million. And my appointment was made when the person said the order passed by this honorable court million. This honorable court
Required them to carry out an inquiry. Required them to carry out an inquiry.
this court filed, well, yes, when the complaint was made, when the complaint was made and the
WPC 4205. My Lord Justice Bhuyan's order.
Yes, yes.
yes, 4205. And this honorable court will dispose of these issues on the basis of this order. The disputed question of fact, and it has been having quoted in this order. And the director, after disposal of this case, the
Anything more? You're working since? Where is your appointment order?
2014.
Your appointment order is on record.
Yes, already
Where?
there. And sir, 33, my affidavit, 33 and 34.
Left. Not Miss L. Borua.
Lordship, I am M. Bura.
M. Bora, Mira Bora, learned counsel for the petitioner. Also heard Mr.
H.I. Chaudhary.
H.I.
Chaudhary.
Chaudhary, learned counsel for the, heard Miss S. Borua, learned government advocate, appearing for the respondents number 1, 2, 3, 4, 5. Mr. H.I. Chaudhary appears for respond number 6 and 7. There is no representation on behalf of the respond number. The petitioner in the present petition has challenged an order dated 30/10/2020 issued by the Child Development Project Officer, Dhokuahana ICDS project, that is the respondent number 4 herein, terminating her services as Anganwadi worker in 117 number Kekuri, Dadabari, Anganwadi Center with effect from 31/10/2014. Also, the facts requisite for adjudication of the issue arising in the present petition noticed as under. In pursuance to an advertisement dated 7/9/2009, issued by the, it will be by the CDPO only,
Yes, CDP.
by the jurisdictional Child Development Project Officer, inviting, dated 7/9, inviting applications for engagement as Anganwadi helper, Anganwadi worker and Anganwadi helper in various Anganwadi centers under Dhokuahana ICDS project. The petitioner herein submitted her application for engagement as an Anganwadi worker in 117 number Kekuri Dadabari Anganwadi Center. It is projected in the petition that a selection was held in the matter and the petition had duly participated therein. It is also projected that after the conclusion of the selection process, a select list was published by the Child Development Project by the jurisdictional child development project officer, and therein the name of the petitioner hearing figured as the selected Anganwadi worker against Kekuri Gadabari Anganwadi Center. It is further projected that in pursuance to her selection, the petitioner came to be engaged temporarily as Anganwadi worker in Kekuri Gadabari Anganwadi Center, and she, in pursuance to the said engagement, joined her services. Also, while the petitioner was serving in such capacity in terms of the order dated 3/4/2013, the petitioner received an order dated 30/10/2014, by which her services were terminated, by which her engagement as an Anganwadi worker in the said Anganwadi Center was cancelled with effect from 31/10/2014. On inquiry being made by the petitioner came to gather that they said that three applicants the three candidates who had submitted their respective application for the post of Anganwadi worker and Anganwadi helper in pursuance to the advertisement dated 7/9/2009 had instituted a writ petition before this court, being WPC number 4205/2011. A coordinate bench of this court, wide order dated 29/11/2012, proceeded to dispose of the said writ petition, requiring the Director of Social Welfare Assam to examine the grievance of the petitioner, if required, by conducting an independent inquiry into the residential status of the petitioners, and based on such examination to decide the claim of the petitioners for appointment against the posts which they had so applied. Also, it was further provided that with the claim of the petitioners of being residents within the Anganwadi Center concerned is found to be correct, the director was directed to pass consequential orders after giving opportunity to the respondents, to the private respondents impleaded in the said writ petition. It is to be noted that the petitioners in WPC number 4205/2011 had raised a grievance with regard to the exclusion of their candidature from the selection process initiated in pursuance to the advertisement dated 7/9/2009 on the ground that the petitioners were not found to be residents within the coverage area of the Anganwadi Center in question. Also, the petitioner further projects that in pursuance to the directions passed by this court in WPC number 4205/2011, necessary inquiries were carried out in the matter, and thereafter the Director of Social Welfare Assam, by an order dated 11/9/2014, proceeded to hold that the respondent number 6 herein was a resident within the coverage area of number 117 Kekuri Adabari Anganwadi Center, and accordingly, directions came to be issued for her engagement. Also, it is petitioner projects that it is on account of the said developments taking place in the matter that the respondent authorities proceeded to issue the impugned order dated 30/10/2014. The petitioner also projects that neither in the proceedings of WPC number 4205/2011 nor in the inquiry process held, which led to the passing of the order dated 11/9/2014, the petitioner was in any manner included, and action against her was so taken behind her back. Ms. M. Bora, learned counsel for the petitioner. Next, learned counsel for the petitioner, by reiterating the facts noticed herein above, submitted that the selection process, this process of selection as held in pursuance to the advertisement dated 7/9/2009 was concluded with the publication of a checklist on 21/3/2013, and thereafter being a selected candidate for the post of number 117 Kekuri Dadabari Anganwadi Center. The petitioner was appointed in such capacity was engaged in such capacity wide order dated 3/4/2013 passed by the jurisdictional child development project officer. She submits that the petitioner, while continuing in her services, had received the order dated 30/10/2014, had received the impugned order dated 30/10/2014, terminating her services. Also, she submits that the termination of the services of the petitioner was not preceded with issuance of any notice to her, and accordingly, she was denied an opportunity to place her case before the authorities in the matter. She submits that the petitioner was also deprived of an opportunity to have her stand placed on record with regard to the residential status of the respondent number 6 herein. So, in view of the above, in the above premises, Ms. Bora submits that the impugned order dated 30/4/2013 would mandate an interference with a further direction to the respondent authority, also interfere with the consequential appointment expected in respect of the respondent number 6 herein. Ms. Bora further pays that the petitioner be directed to continue in her engagement as an Anganwadi worker in terms of the office order dated 3/4/2013. Anything more? Ms. S. Borua, learned counsel, learned government advocate, appearing for the state respondents, as by referring to the affidavit filed in the matter by the circle officer, the Guahana Revenue Circle, submits that in the selection process that was held in pursuance to the advertisement dated 4/9/2000, the petitioner was placed at serial number 3 on merits. The candidates placed above the petitioner, including the respondent number 6 herein, were not considered for appointment, as it was held that they belonged to an area beyond the survey area of the Anganwadi Center in question. Ms. Borua submits that the exclusion of the said selected candidates, including the respondent number 6 herein, being challenged before this court in the proceedings of WPC number so-and-so 4205/2011, in terms of the directions passed by the coordinate by this court-wide order dated 29/11/2012, an inquiry was carried out in the matter, and accordingly, and therein it was found that the respondent number 6 was a resident within the coverage area of the Anganwadi in question, and accordingly, her right to be engaged as an Anganwadi worker was established. Also, Ms. Borua submits that in terms of the said determination made pertaining to the residential status of the respondent number, the respondent authorities proceeded to issue the order dated 30/10/2014, terminating the engagement of the petitioner herein. Also, she submits that in pursuance to the termination of the engagement of the petitioner, the respondent number 6 was appointed as a Anganwadi worker in terms of the merit position obtained by her in the connected selection process. So, in the above premises, Ms. Borua submits that there is no irregularity committed by the respondent authorities in the matter, and accordingly, the cancellation of the engagement of the engagement of the petitioner. Accordingly, the cancellation of the engagement of the petition order dated 30/10/2014 would not mandate an acceptance by this, would not mandate an interference from this court. Mr. H.I. Chaudhary, learned counsel for the petitioner, submits that adopts the arguments advanced by Ms. S. Burua, learned government advocate, and submits that the residential status of the respondent number 6 being determined by the respondent authorities, the respondent authorities proceeded with an office order dated 31/10/2014 to engage her as the Anganwadi worker of the Anganwadi center in question. He submits that the petitioner, respondent number 6, with effect from the date she had joined her services in pursuance to the order dated 31/10/2014, is continuing there against till date. Accordingly, he submits that in view of the facts and circumstances involved in the matter, the order date, the engagement of the petition of the respondent number 6 as an Anganwadi worker of the Anganwadi center in question would not mandate an interference. Heard the learned counsel for the parties and also peruse the materials available. The facts noticed herein above are not in dispute. Also, the petitioner was found to have the respondent authorities have projected that the petition was placed at serial number 3 in the selection process as held in pursuance to the advertisement dated 7/9/2009 for the post of Anganwadi worker in Kekuri Dadabari Anganwadi Center. The respondent number 6 herein was placed above the petitioner. However, on account of a fact that the residential status of the respondent number 6 was disputed, the respondent number 6 was excluded from the selection process, and the petitioner herein came to be engaged as an Anganwadi worker against the Anganwadi center in question, while issuance of a order dated 3/4/2013. As noticed herein above, the exclusion of the respondent number 6 from the purview of the selection process was assailed by her by way of, along with 2 others, by way of instituting a writ petition being WPC number 4205/2011. In terms of the directions passed by this court, by a coordinate bench of this court, order dated 29/11/2012, while disposing of the said writ petition, the respondent authorities proceeded to conduct an inquiry in the matter. Also, on receipt of the reports from the authorities of the district administration pertaining to the residential status of the respondent number 6 herein, the director of Social Welfare Assam proceeded order dated 11/9/2014 to hold that the respondent number 6 herein was a resident within the coverage area of 117 Kekuri Dadabari Anganwadi Center. Also, the residential status of the petition, respondent number 6, now being answered in favor of her favor, and she being found to be a resident within the coverage area of the Anganwadi center in question, the petitioners, respondent number 6 merit as obtained by her, the merit position as obtained by the respondent number 6 in the connected selection now gets revived. So, the authorities having found the respondent number 6 to be placed above the petitioner in order of merit in the selection process so held, proceeded void an order dated 30/10/2014 to cancel the engagement made in her favor earlier, void an order dated 3/4/2013 as Anganwadi worker of the Anganwadi center in question. Also, they said the engagement of the petitioner having been cancelled, the respondent authorities proceeded to appoint the petition, but the respondent number 6 as an Anganwadi worker of the Anganwadi center in question by the order dated 31/10/2014. Also, what is noticed by this court in the present in the proceedings is that while the respondents have made categorical statements with regard to the merit position obtained by the petitioner and the respondent number 6 in the connected selection process, the petitioner in the present proceedings have not disputed this said proceeding. Further, the conclusions drawn by the Director of Social Welfare with regard to the residential status of the respondent number 6 is also not found to have been disputed by the petitioner in the present writ petition. Also, in view of the above discussion, this court finds that the engagement of the respondent number 6 herein being on the basis of her merit obtained in the selection process and she being placed in on such merits above the petitioner herein, the cancellation of the engagement of the petitioner by the impugned order dated 30/10/2014 in the considered view of this court would not mandate an interference. Also, accordingly, the consequential engagement of the petitioner of the respondent number 6 affected by the order dated 31/10/2014 in the considered view of this court would also not mandate any interference. Also, in view of the above, the present writ petition is held to be devoid of any merit and accordingly the same stands dismissed. However, there would be no order as to cause. Also, I'll dispose this, let her type it out, dispose it. But you will not get the order within 2-3 days, I'm telling you. Both dismissed, huh? Can't help it, Ms. Bora. 2015, you tried your best.
I'm so grateful to your lordship. While your lordship was dictating, then only I have understood my merit position, lordship. Obliged, lordship.
Because that fact coming to my notice, how can I ignore that?
I'm so grateful, lordship.
But it's not the end of the day for you. It's only, it's not the end of a day. It's just a half win. You still have options open to you. Iman? Yes, Mr. Upon. What have you got?
Lord, I'm seeking some accommodation today, my lord. The matter can be taken up, my lord, on some other day, my lord. Because it's an old matter, my lord. The person was supposed
Mr. Fukon, learned counsel for the, what was the name of the boy who appeared in the morning?
to.
The name to level excel. Isani? No, not again. But Mr. Lekhasun, but Mr. Lloyd, Mr. Fukon, we'll pass the order. Let the young guy come.
No.
Don't want to. Yes, Mr. Ghosh, what have you got?
I've been told that they are trying to trace out the physical.
Forget it. Where are they? They are physically here.
No, Lordship, I've been told by the officer that to ascertain whether they're still working or not, those records will be necessary. They are still.
Where are you working? You don't have instructions.
Yeah, Lordship, as my senior is out of station, or some instructions are required in the matter.
On the prayer of the parties, I heard the matter at some length. of the Learner Council for the parties on the prayer made by the joint prayer made by the Learner Council for the parties registered to list this matter again on 24/3/2026.
Obliged.
No further adjournment shall be granted in the matter.
May please, Your Lordship. May please, Your Lordship. Lord, the matter relates to my lord, no confidence motion against the chairman of Dergaon Municipal Board, my lord. That impugned resolutions, Lordship will find at page 43. Page 43, my lord.
This was heard by a coordinate bench. Lordship,
Excel part hard, my lord, but
so should we send it back to that bench or?
as your lordship deem it, my lord.
Lordship, as per no confidence motion, the petitioner also present. And she
Yes,
also,
what is your case? Page?
43, my lord.
You are Rupanjali Bora.
Yes, my lord. I'm the chairpersons of the my lord Dergaon Municipal Board.
What is the basis of this resolution?
Yes, my lord, the only, my lord, the at page 44, my lord. The minutes of the meeting, the 9 members out of 9 members, my lord, out of 10, my lord, have expressed their opinion in favor of no confidence motion.
No, how does it start?
Requisition.
Now, if I have to hear it, I'll have to hear it from the beginning.
Yes.
Oh, how did it start? Requisition.
Yes, requisition lordship will find page 38.
You were elected
I am elected.
when?
In the March 2022.
March
2022.
elected as ward member.
Yes, ward member 9. Ward number
Ward
9.
member of ward number 9.
My lord.
Then,
my lord, I was
when were you elected as chairman or president? How do you call it? President?
chairperson.
Chairperson.
Yes.
When?
My lord, immediately, my lord, on the first meeting of the my lord Dergaon Municipal Board, my lord.
Mr. Counsel, you can have your seat.
Then, my lord,
It's a municipal board or a council?
Municipal Board.
Board.
Page 38 is the my lord requisition letter. My lord. (19/11/2024).
Page?
Page 38. This requisition is, my lord, followed by my lord, a meeting was held on 19/11/2024. That lordship will find page 39.
No, this is the starting 19/11/2024.
Yes, my lord.
Requisition by
By my lord, 9 members. Then my lord, page my lord 37, my lord, the executive officer issued a letter asking me to convene a meeting. That is dated 6 December 2024.
special meeting.
Yes, my lord, special meeting.
Some Municipal Act 9. Yes.
And the meeting was held on my lord 9/12/2024. That lordship will find page 43.
Type copy is at page.
Yes, yes. Type copy, vernacular lordship will find that page 46.
And what is this 39?
39 is the meeting held by the members, 9 members expressing my lord no confidence against me, my lord. That was forwarded to the co-district commissioner by letter dated page 38.
No meeting was called by the chairperson for this page for 39.
Yes. No.
This was between them.
Between the 9 members.
Then the meeting convened by the is 43.
Page 43. And here lordship will find in the that the allegations has been again my lord discussed, and the lordship will find page 44. Second last paragraph, my lord.
The motion was passed.
Not my lord, actually, it has been recorded that 9 members of the municipal board opined in favor of no confidence against the chairperson, accepted the resolution of no confidence. I challenge, my lord, this interim resolution is on 3 grounds, my lord. My lord, ground number 1 is, my lord, no votes as required under section 28(2) of the municipal act. Secondly, my lord, the minutes of the meeting.
No vote cast under section
28(2). 28 within bracket 2, my lord, subsection 2. And the minutes of the meeting had not been recorded in the proceeding book of the, my lord, municipal board, my lord. That is required, my lord, under section 47, subsection 1.
Nanigidu.
And my lord,
Under section?
40, subsection 1, section 47.
Then
And third ground is, my lord, the minutes of the meeting, my lord, that impugned meeting, my lord, has not been laid in the next meeting and no approval has been obtained, my lord. That is, my lord, required under section 47, subsection 3.
subsequent meeting held on?
Subsequent meeting held on, my lord, 11/12/2024, case 49.
And that is required under?
Under subsection 3, section 47.
So these are the three grounds.
Yes, my lord, these are the three grounds.
Now let us come to the first ground.
Yes, my lord. That impugned resolution itself, my lord, reflects that there is no vote, my lord.
First
Provision, my lord.
section
28(2). Is 32, my lord. Removal of chairman and vice chairman. An elected chairman or vice chairman may be removed
But
from
here, a secret ballot is not provided for.
secret ballot, not provided because that's
This
why.
vote can be also by raise of hands.
But my lord, the procedure, this is the prescribed procedure, my lord. They have to be followed, my lord, the prescribed.
They have their 9
Opinion, my
have
lord.
given their
My lord, my submission is that the opinion.
law that in the municipal board 28(2),
Yes.
a ballot is to be
No,
resorted.
I am not saying ballot, my lord. Vote, my lord.
Vote can be given like this also.
But that is not expressed in the, my lord.
That 9 thing we will have to deem it to be.
My lord, my submission is that.
Show me a law.
No, my lord.
Show me a law on this point.
I have searched, my lord, but
There is nothing. They cannot be. It's an expression.
no expression, my lord. They have already given by way of requisition, my lord.
Fine. In that meeting.
That's why, my lord, the
in that
law
meeting,
prescribes this, my lord.
have you arrayed them as parties here in the repetitions?
Members, my lord.
No non-confidence persons. The no persons who have given the no confidence requisition. Have you arrayed them as respondents here?
All are arrayed.
So this goes 28.
No, my lord. My lord, I am saying that in the subsequent meeting that lordship will find in the page 49.
We'll come to that.
No, my lord. Why I am saying that the procedure adopted in that meeting is the correct one as prescribed under the law while selecting the, my lord, next chairpersons. That
40.
lordship will find page 51. Voting is there. Page 51, para number 4. This is the subsequent meeting. This is the special meeting, my lord, and law prescribes that. It does also not reflect that why the secret ballot was used or, my lord, by raising hand, that is not reflected. But voting is, my lord, process has adopted. My submissions is that the expression opinion has already been given by way of requisition. So in the particular, my lord, it has been reflected that motamot, my lord.
Just a moment. Subsequent meeting is of 9.
Yes, subsequent is meeting of my
11.
11/12/2024.
Okay, then
My lord, my submission, the procedure prescribed, my lord, under the municipal act, my lord, has to be followed in all the meetings. That's why lordship will find, my lord, section 45A.
just a moment.
Lordship, for a moment, my lord, section 45A, page 42. All questions at a meeting of the board shall be determined by a majority of votes. 28(2) is, my lord, special meeting. This is the, my lord, all the meetings.
Yes. This is with regard to your first point.
Yes, my lord.
Second point.
Second point is, my lord, that the minutes of the meeting, my lord, has not been recorded in the, my lord, proceeding book of the, my lord, municipal board, my lord. And that part, my lord, they have also admitted in the affidavit file, and they have made a statement, they have, my lord, incorporated in the letter part. That, my lord, page 100, my lord. This is
They
the
have incorporated but late subsequent.
letter, my lord, they have said that letter, my lord. My sub, in
Page,
the affidavit, page 100.
para?
Para 15. This is the affidavit filed by the, my lord, respond number 5 and 6, executive officer.
Yes.
My specific, my lord, apartment in my petition also that the minutes of the meeting has not been recorded in the, my lord.
And that they have said what more is
Yes,
there.
my
Then
lord.
next.
And next, my lord, is the minutes of the meeting, my lord, have not been laid, my lord, in the next meeting, and that has not been approved.
That
That
is,
is
you are referring
required
to
47(3).
47(3).
Minutes of the proceeding 47, my lord.
Anything more? Anything more?
My lord, that the minutes of the meeting, my lord, next meeting, my lord, I have annex, my lord, that there is no any whisper, and that has not been, my lord.
How does it undermine? The first point, okay, fine, we'll examine them. Putting. If that is perfect, the other 2 points are.
But, my lord, I
Does
have
not-
raised it, my lord.
Yes.
Lordship, as per the first point, Lordship, the Honorable Justice, Lordship, in my affidavit, additional affidavit, Lordship, running page number 131. Honorable Justice already dismissed this type of writ petition, Lordship, where there is also no confidence motion was against the petitioner, Lordship, and in that case also, Lordship, page number 139, paragraph 4, last part of the paragraph 4, Lordship. In that case also express there are no confidence motions, Lordship. In that case also there is no secret voting. 131, Lordship, page number. In my additional affidavit in opposition.
Anything more? Yes.
Yeah, and
Next.
and lordship, the meeting was called by the petitioner lordship. In my affidavit, annexer R2,
Hmm.
and lordship subsequently the board meeting was held and nine members in favor of the no confidence motion lordship.
You are appearing for?
Lordship, I am appearing for the respondent number 7, 8, 9, 11, 14 and 15 and
So those are the members.
members, yes, lordship.
Your name? Your
My
name.
DJ Boro lordship. And regarding the procedural left lordship, one judgment I want to place lordship, Padmini Singha judgment.
Hmm. Hmm. Second point, that your meetings was not recorded immediately in the proceeding.
Lordship, section 47(3) also stated.
No, that is 47(1).
Also kindly see, Lordship, 47(3), the minutes shall be laid before the next meeting on board confirmation and shall also be signed to the such meeting by the president if the sum has been correctly entered. In that, Lordship, 11/12/2024 meeting, the petitioner was not present in that meeting.
This president would be the president of that meeting, whoever is the president. Why was it not signed? Or is it just a technicality which will not undermine the resolution already adopted?
Yes,
Yes. Who is he appearing for? What is your case?
Pilot, we are in supporting of the.
What is your name?
Ede.
Eh? Ede. You're for respondent number?
Number 10, 12.
Yes. Who is for the state respondent? Mr. Das. Yes. You have filed an affidavit?
Yes, sir.
Huh?
It's elected vice chair. By a resolution of the board in favor of which not more than half of the whole number of votes are for that purpose.
What is this votes?
It says by the votes. It's very sick.
Ballot is different. Voting, what Mr. That's it. What Mr. Sharma is trying to emphasize is that there has to be a symbolic expression of a voting. Voting can be like this. Voting can be by way of ballot. It can be an open thing also. But here in the resolution, there is no reference to that. Opine, different thing, but opining and vote. This is his last straw. So he will naturally develop that.
If he also get well, right? It says all question at a meeting of the majority of the votes.
Votes.
Votes. And I submission.
There is definition of the word term vote somewhere, no?
No.
Interesting. Simple, I can hold it, but why? We'll do something. We'll see. Where is your affidavit here? Page? $57 to?
Seven.
And what do you say about the other 2 points?
It's a very full. One will go more share, but 3 itself was petition.
This is 9/12 meeting. That is admitted.
You have filed this affidavit by way, on behalf of the Deputy Commissioner. Okay. Anything more? And what about the thing that the minutes of the 9/12 was not confirmed in the subsequent 11/12 meeting? $62.
Meeting and third view proceeding. For a settlement in what? And in.
No, why was it not placed in the subsequent meeting? Rupa Dutta is in a different plane altogether. It's got
Quorum regarding.
It's a quorum that 46(3), how many days of notice is to be given? Any other decision? No, that is the only decision.
But in that case also, Lordship, the no confidence motion was expressed.
For that point, you are relying on that.
Yes, Lordship.
Okay. Anything more, Mr. Shawan?
And Podmil Singh's judgment, para number 13.
Okay.
Judgment, Lordship, I have given. Para number 13, Lordship.
No dispute with the original records. But Mr. Sharma. Hearing concluded. Registry to list this matter in. You have it. No. Property. I follow it. 30 quid. 30,000. 2,000 quid. Huh? I'll have to read of it. Not dealt with this matter only. Panchayat, I have, but municipality, that law I'll have to. That's it. Interesting.
I have searched, my lord, but not.
If I
contained.
have anything, I'll let you know on that day. If any clarification.
Obliged, my lord.
Not obliged.
What's your name?
My lord, M. Hazarika, my lord.
M. Hazarika. But Mr. M. Hazarika, learned counsel for the petition at some length. Mr. A. Fukan, learned counsel, appearing for the
1 and 2.
for the respondents number 1 of standing counsel, Secretary and Administration Department, appearing for the respondent number 1 and 2. Praise that he be given time till today, Azikiman, Kutoro. Time till 27/3/2026 to produce the to produce the file, to produce the records of the file number, to produce the records. More particularly, file number SN. Yeah, go order to the SSILB. As bracketed N 102/2005/PT. Also, Mr. Fukan shall also receive instructions from the respondents, from the respondents represented by him, with regard to the submission made by the learned counsel for the petitioner, that in the list of fixed pay workers, fixed pay casual workers,
Yes, daily wage workers, my lord.
daily wage workers as available at Annexure 7, page 64-65 to the writ petition. Persons at serial number 53 to 59, right?
Yes, my lord. And
Where
42
not-
also, my lord.
Huh?
And 42 also, my lord.
42,
number 42
serial number
also.
42,
Yes, my lord.
53 to 59 were also not found to be incorporated, or not to be names of the persons included at serial number 42, 53 to 59 of the said list is also not found to be included in the earlier list brought on record as Annexure 6 to the writ petition. Also, Mr. Fukan shall clarify as to the said aspect of the matter on the next date of listing.
My lord, finance did not make a representation today, my lord. The finance department, my lord, there was nobody to make the representation on behalf of the finance department. Life, my lord.
20, I give him a copy.
Yes, my lord, I'll do it right now, my lord.
27. Sir, Fukan,
20,
get
my
that
lord?
file.
27th.
27. Get that file
Hello.
and this instruction.
Hello.
Why this incorporation book? And please be prompt here.
Hello.
It's a matter of
15, my lord.
15. We are not going to adjourn it any further. For further hearing today.
Yes, my lord.
Happy to lecture.
The case of reinstatement service as well as regularization. My lord, petitioner was serving in the Assam Tea Plantation Security Force in the year 1993. Thereafter, he undergoes training of 54 days initially at Fort APBN, and he continued his service till 12/2003. Thereafter, he was verbally directed not to continue in view of one FIR in Bihali police station. Subsequently, that
And you are such a disciplined personnel. Officer said, don't come. You also did not go. You also sat tight from 2003 onwards.
My lord,
Till 2017.
yes, my lord,
14 years.
my lord.
Huh? Now, show me. What is your explanation with it?
Explanation, my lord, I have given in my paragraphs there several things, but what happened? I contested the case. I was acquitted in the year 2016. And my lord, this
Mr. Sharma, too much. 2003,
yes, my lord.
you don't have a service, and 2017 you come up before this court.
Only after acquittal, my lord.
Acquittal also, you come
And
to the
thereafter-
acquittal order.
I have given representation, and my lord, in the affidavit, respondent's affidavit, my service was recognized, and kindly come to the order, my lord, of this court, that is 18/12/2017.
812.
18/12. There was a direction from this court to the respondent.
Okay, show me your appointment.
I don't have any appointment, but I have a certificate, service.
Why? You don't have, seems to, you don't have anything.
Because
How can you get into a government service? This is a command certificate.
yes, comments. Nearly
And if
300
this,
persons
if you
were
don't have an
appointed.
appointment,
In that way, my lord.
command certificate, I don't know how this was issued. What is the stand with, let us see the affidavit of the government.
Yes, my lord. They admitted my service certificate.
Come to page 72, para 5.
Yes, my lord. Down below, my lord. However, it is a fact that command certificate are issued to the petitioner.
Certificate can be issued even to Home Guards.
My service was like that, my lord, at that time. I was serving as a home guard. Subsequently, after
Because at that point of time, this force was not properly constituted.
not constituted, there were judgments of this honorable court. Thereafter, 2 battalions were raised by the government.
So, till that time, how can you claim anything?
And that last order, my lord, is of 16/2000. This process was going on, my lord. Kindly come to the order, that is page 44.
And see, you were asked to go in 2003.
Yes, my lord.
And you have not even approached your authorities that say, I'm working merely an FIR, what will happen? I should be continued.
Layman, my lord, not duly instructed in law. That is the fact, my lord.
Now, I can't allow the taxpayers' money to be expended on a person who is not even there.
But what happened, my lord? The order was of 2016. This process was going on. There are so many petitions by the service fellow servicemen.
Okay,
So
come
this
to that command certificate just for a second again.
My lord. Command certificate as well as there is a service certificate also, my lord.
By that commissioner, some commissioner.
Yes, my lord. Generally, their appointments are by the SP rank officers. And 56, page 56 also is a certificate, my lord. Page 56. By the commandant. So these are the things.
Swama, what is this certificate?
My lord, page 56. He was working in 13/11 to 12/12/2004.
30/11/93 to 12/12/2003.
Three.
93 to 2000.
Yes, my lord. Yes, my lord. This is the fact, my lord. And my lord,
You were there on daily wages.
At that time, I was there, my lord.
Daily wages.
Yes, my lord. Thereafter, these are the two judgments which, my lord, Honorable Court allow similarly situated persons to be regularized. This is of 2015, my lord.
You are around 57.
54, I think, as far my knowledge is concerned. I have three daughters, my lord.
Affidavit reply, his age is shown as 43 and writ petition
No,
56.
That is Mr. Sharma's typist, sir.
Handwriting, not typing. Page 12, 46 at the time of filing the writ petition. And while replying to the affidavit, his age reduced to 43. I don't understand. Within 2 years.
Only one affidavit by the respondents, no?
Yes, my lord. In view of this two order of the High Court, my lord, this order dated 24 October 2016 was passed by the government.
Yes, Mr. Sudhir.
My lord, apparently this command certificate, I don't believe it.
Mr. Sharma, one thing. What is the stand with regard to your discharge here? The affidavit?
No, but order reflect that kindly come to the order dated 1812. There was initially some instruction, but they failed to prove that stand later on.
Yes. So, Lordship, kindly, first of all, going to ballot Honorable Court's order, page 69, the operative portion, paragraph 9. Consequently, order reasons alluded in the foregoing paragraphs, this repression has to be allowed. The state respondent will now examine the question as to whether the further continuance of the force in the future would be necessary, and if so, to give permanent status along with the consequential time scale of pay to such members of the force who may be in service as on death. The existing framework under which the force continue to operate will necessarily have to undergo certain structural changes at the hands of the authority. If, however, the continuance of the force raise any room for doubt and speculation in the minds of the authority, the concerned state authorities will ensure continuance in the employment of the members of the force till such time that the force remains in operation, and simultaneously embark upon the package of fast rehabilitation of the members of the force. The direction in favor of the members of the force as herein above is necessarily subject to their being found fit and eligible for continuance in active service. No time limit has been fixed to compel performance of the obligation cast upon the state authorities by this order, and this court sees no reason as to why the authorities will not carry out the obligation within a year. My question is, my lord, these are the what happened, my lord, in 2012 also, when the troublesome area like Kukurajar, Nagaon, Dhubri, and National Highway, there are some person, those are belong to home guards, and they were deployed to that area, and some were engaged as a PSO and some were the home guard. So they thereafter some 1 year or half, 6 months like that, my lord, they were retained, and thereafter they make an association, they press the government, they are to be rehabilitated. Accordingly, my lord, so to my knowledge, my lord, I have conducted these cases. According to 2017-18 advertisement made for absorbment of these persons, those who were in the troublesome time, my lord, they were deployed in the Kukurajar, Dhupuri.
Is that not
No,
reflected in
I'm
your
telling you.
affidavit?
No, I'm telling you, my lord, the facts. Now, I know well, I conducted the other cases, my lord. 17-18 makes advertisement, first 140 personnel to CIF, appointment CIF from those persons who are working as a PSO and subsequently they were terminated or otherwise home guard, those who are working. And accordingly, interview was held, selection was made, appointment has been done. And subsequently, another 200 and another 6,000 something, my lord, made. And the petitioner, he was in the jail. I think he could not apply it. But perhaps he could have applied because 2016 he was released from the criminal court. So he did not apply. I think, my lord, that was the fact, background. I know well, my lord. So that was, my lord, the PSO and home guard, those who were detained from the service, my lord, there was a certificate and appointment letter is there. Appointment letter is there as a home guard, and they will send from time to time, my lord. Yeah, and this person also conducted, this person also covered by the Home Guard Act 1947. The memorandum of minutes of memorandum he has, my lord, we did the government and the, my lord, lordship kindly see page 15. Memorandum of Understanding between the Governor of Assam and the Indian Tea Association regarding raising of Assam Tea Plantation Security Force. Because at that moment, some extremist group disturbed this tea plantation area, and they decided, and they have a memorandum of understanding, they have made it, and they have said that they will
You mean
provide.
to say that these people who were recruited as
Not by the government.
Assam Tea Plantation Security Force, they were literally thrown to the fire.
Yes.
They were thrown to the fire.
And they were as a security.
You took a long time to redress the petitioner, different. But the others now have been redressed. They have been given some semblance of dignity.
Yeah. Their dignity means, my lord, they were advertisement made and they participated and appointed person. And petitioner also, those belong to those persons, same person.
Okay. Mr. Sharma.
Petitioner has no, my lord, otherwise case.
Gopal,
I know well, I conducted all these cases.
Submission that he was in jail during that time. This is a wild submission.
I don't find your services at that point, not only yours, none services to be of a permanent nature because the force was not created.
Yes, my lord, admit
it was just a temporary sort of an arrangement.
Yes.
For the tea gardens.
Tea gardens.
So you went out.
Yes, my lord.
You went out.
Yes.
Subsequently, there were two forces, two battalions.
Reorganized.
You were given an opportunity to apply for that.
Yes.
Yes, my lord.
It is not that these people were taken and put there.
Yes.
It's not that. That was my doubt.
Yes, yes, well.
So the factual matrix is that you all were unorganized sort of a thing for the tea gardens. They were using your services. Thereafter, these people, and in terms of the directions of this court, government raised 2 battalions.
Yes, my lord.
And normally what happens is when a battalion is raised, the people who are there, they are absorbed. Here there was no absorption, there was a recruitment, but you were given some preference maybe. And you became members of that battalion from the date of your absorption.
Kindly come to page 45.
45.
Without, they were absorbed, not appointed, my lord, because this honorary PC,
Where?
page 45, my lord. They were, as it is invited for training, further training,
Just a minute.
first batch of training, second batch of training.
Those were home guards.
Yes, admittedly.
They were home guards. They said
Just a minute.
While also in page 44, honorary Nayak and less Nayak are drawing pay and allowance as their post they were holding at APTSF except regular rank in AISF.
You were not given a home guard certificate, command certificate.
No.
Guard
Command certificate was there.
No,
but
no, home guard certificate.
No, my lord.
no expense
At that
certificate.
time,
It was that this organization is to be managed like the home guard organization.
the
That
home
much.
guards.
It is funded by the
Like-
tea association, my lord.
Now, when
Indian tea
this,
association funded.
highway authority is working at that time, also some retired persons were
SPO.
taken.
That is
Yes,
SPO.
SPO.
They also not been regularized.
No,
Not
regular-
They have been given a benefit in
Benefit.
the for recruitment in the
Yes.
police force.
Yes,
Yes,
sir.
police
Yes,
force,
sir.
yes. Advertisement made.
Give me
You
2
know-
minutes. Give me 2
Yes,
minutes. Anything more, Mr. Sharma? You missed the bus, unfortunately. We can't put the clock back. Lekha.
Is the situation, my lord. I have 3 daughters, school-going daughters and all. And after immediately, my
Mr.
lord,
Sharma,
acquittal.
You are before a 226 code. We'll have to be very careful
Yes,
when we
my lord.
pass some orders.
Yes, my lord.
See, I was trying to satisfy myself that what I'm going to do, what I proposed to do was perfect.
Exactly, my lord.
That's why I just held back myself.
Yes, my lord.
Now you see what happened. 93, you were recruited.
Yes, my lord.
It was a recruitment basically for the
Security
T
purpose.
T state.
T.
Security of the T state.
Now, what has happened is you continued.
Yes.
In the meantime, because of your nature of the duties, literally you people were being exploited. Literally. So you formed a committee, and that committee came up before this. This court took up the matter very seriously. Allah Justice Google took up the matter very seriously and even went to the extent holding that this is violation of Article 21. And then proceeded and said, okay, create a new permanent structure for them. Take a decision, create a new permanent structure. And in the permanent structure, see how they can be adjusted. If you don't create a permanent structure, continue with them, phase them out with a rehabilitation package.
Yes.
This is the broad thing. Government arrives at a decision that, okay, we are going to raise 2 battalions, 1326 each. 2 would be 2652. Therein they said, okay, 88, some home guards somewhere there, we'll bring them. That post, we'll bring it here. So the post now required to be created is 2564. Then the decision was how you will come in. There was a screening committee made. Every ASTSF people were asked to come.
Yes.
You did not go. You did not raise any grievance at that stage.
Yes, ma'am.
That you were prevented because you were asked to go, whatever X, Y, Z reason, you did not appear before the screening committee. The screening committee went ahead, created those posts by populating them with your people and then from outside, who were not there from outside. Now tell me how today we can put you back.
My lord, when order was for 2016, my acquittal was also of 2016, my lord.
No, you did not go. Show me one statement somewhere that you took part in that screening process.
No, that was not. But I have filed representation, my lord.
The representation is of 2017.
17, my lord. After collecting all these things,
By the time the whole thing had passed away. Like I heard Mr. P.K. Sharma. I'm sorry, with a heavy heart, but can't help it.
Well, can one thing be done that if respondent authorities allow me to appear before the authority if
No,
I am found suitable, then
Today, 57 years,
We have a lot of
discipline force may sound very harsh, but I am helpless. I can't do anything. Leha. Heard Mr. P.K. Sharma, learned counsel for the petitioner. Also heard Mr. T.C. Chutia, learned additional senior government advocate appearing for the respondents. The grievance raised by the petitioner in the present proceeding is for a direction upon the respondent authorities to reinstate him in his services along with all consequential benefits in either of the 2 Assam Industrial Security Force battalions created by the respondent authorities for accommodating persons similarly situated like the petitioner herein who were initially engaged in the Assam Tea Plantation Security Force. Also, paragraph, next 3. The state respondents, along with the had entered into a memorandum of understanding with the Indian Tea Association with regard to raising of Assam Tea Plantation Security Force for the purpose of providing security to the various tea gardens functioning under the Indian Tea Association. The recruitment of personnel against the said post while was to be made by the state of respondents, comma, the payment for management, payment of the expenditure involved, including the salaries of the personnel so recruited, was to be borne by the respective tea gardens. For the purpose of operationalizing the said force, it was provided that the provisions of the Assam Home Guards Act 1947 would be applied. Also, the petitioner contends that after the setting up of the said force, he was engaged by the respondent authorities as a personnel in the Assam Tea Plantation Security Force. Also, the petitioner also contends that for the different works carried out or different duties discharged by him, which also included duties requiring handling of arms and ammunition, comma, he was issued command certificates by the respondents. Also, the petitioner, during his such engagement in the said force, hereinafter referred to as force, was alleged to have been involved in a criminal case. Also, the petitioner, a FIR was lodged in the matter on 30/6/2001 before the officer in charge Behali police station, wherein it was alleged that the petitioner, along with certain others, had committed dacoity by snatching away rupees 8,20,000 from the informant of the said FIR. Also, the said case was registered under section 395/397 IPC against the petitioner herein. Subpara. The petitioner projects that after the registration of the said FIR and his arrest he was arrested? No. Registration of the said FIR, comma, the authorities, competent authority of the force had asked the petitioner not to continue in his services with effect from 12/12/2003. It is projected that the petitioner, complying with the directions issued to him, had not attended his duties after 12/12/2003. The service rendered by the petitioner from (30/11/93) to 12/12/2003 is envisaged to be is sought to be established from a certificate issued by the commandant ATPFSF force, commandant of the force, which is stated to have been issued on 5/11/2005. Also, the petitioner, now not being a member of the said force, comma, certain developments had taken place in the matter. Also, in pursuance to proceedings instituted before this court by persons similarly situated like the petitioner who continued to serve in the force, comma, this court, in the case of All Assam Tea Plantation Security Force Welfare Committee versus State of Assam and others, reported in 2002 bracket 2 GLT 55 proceeded to direct the respondent authorities to examine the question as to whether further continuance of the force in future would be necessary, and if so, to give permanent status along with consequential time scale of pay to such members of the force who may be in service as on date. Also, the directions passed being relevant is extracted here in below, page 25, A to A. Also, in terms of the said directions passed, comma, the government arrived at a decision to create 2 battalions of to create a new force in the name and style of Assam Tea Plantation and Industrial Security Force. Also, in terms of the decision arrived at, the strength of each of the said battalions would be 1326 numbers of personnel, and post creation for the purpose would be done by the government. Insofar as the personnel working in the force is under in the Assam Tea Plantation Security Force is so concerned, comma, their cases were decided to be so examined by a board to be constituted in the matter by the government, and the board, upon screening such members of the force continuing in their services, would select them, and they would be subsequently deputed for training. On completion of their respective training, such personnel selected by the said board would be absorbed in the new battalions created. Also, it is submitted, thereafter, the government of Assam, in terms of the decision arrived at, created 2 battalions in the name and style, apostrophe, number 3 Assam Industrial Security Force Battalion and number 4 Assam Industrial Security Force Battalion, to absorb the eligible personnel of Assam Tea Plantation Security Force under a permanent structure. Also, it is submitted at the bar that the personnel of the said Assam Tea Plantation Security Force who had appeared before the board constituted in the matter, upon screening their, upon examining their suitability, and after they had undergone the prescribed training, were placed in the newly raised forces, battalions of the AISF, some industrial security force. Also, it is further projected that on conclusion of the process involved, around 2571 personnel were appointed in the said two forces. Also, the petitioner, however, has not projected in the present writ petition that he had also submitted his candidature for absorption against the two battalions created by the order dated 22/4/2008 in terms of the decision arrived at by the government in the matter. Also, the criminal proceedings instituted against the petitioner in the matter on conclusion of trial, on a full stop. In the criminal proceedings instituted against the petitioner, after conclusion of trial, the trial court-wide, the learned trial court-wide judgment dated 30/9/2016 proceeded to acquit the petitioner from the charges framed against him therein. Also, the petitioner, on being acquitted from the criminal proceedings pending against him, proceeded to submit a representation dated 6/4/2017 before the Commandant, Assam Industrial Security Force, praying for his reinstatement in service and for granting permanency, along with consequential time scale of pay. The said representation, however, was not favorably considered. Also, the learned counsel for the petitioner, as well as the learned counsel for the respondents, have reiterated the factual position as noticed, existing in the case and as noticed herein above. Also, the facts narrated herein above would reveal that the petitioner, on being asked not to continue in his services in the force with effect from 12/12/2003, had not assailed such directions issued to him by the authorities of the Assam Industrial Security Force, wherein he was at the relevant point of time engaged. The petitioner is not found to have
This is that at that time Assam Tea Plantation Security
Assam
Force.
Tea Plantation Security Force. The petitioner is also not found to have raised any grievance in the matter proximate to the time when he was prevented from continuing in the service of the Assam Industrial Security Force. By it, ATPFS. Full stop. The petitioner had, for the first time after 12/12/2003, approached the authorities praying for reinstatement in service only on submitting his representation dated 6/4/2017. That is, the petitioner had approached the respondent authorities after 14 years from the date when he was prevented from continuing with his engagement in the ATPSF. The delay occasioning in approaching the respondent authorities and/or this court for redressal of these grievances is not explained in the writ petition. Also, the writ petitioner has also not full stop. A procedure, as noticed here in above, a procedure having been put in place for the purpose of absorbing the services of the personnel engaged in ATPSF in the two newly raised battalions of the AISF, Assam Industrial Security Force. The petitioner in the present writ petition has also not brought on record any material to demonstrate that he had offered his candidature for such absorption, but was not considered for the purpose for reasons that may be known to the respondents. The petitioner is found to have not submitted. The petitioner has been found to have kept away from the said process initiated in the matter, while his erstwhile colleagues in the ATPSF had participated in such process, and they, on being found to be suitable for absorption in the two newly created battalions of AISF, were duly absorbed and subsequently also extended with scales of, they were subsequently also authorized a scale of pay along with other benefits that would flow to a police personnel working in the normal police force of the state. Also, the process as put in place for absorption of the earlier employees of ATPFS, some tea plantation, ATPFS, SF, in the newly created two battalions of AISF was a one-time measure to raise the two newly created forces, and the petitioner not having participated in the said process after lapse of participate in the said process, this court at this stage would not direct the respondent authorities to consider the case of the petitioner for such absorption, inasmuch as the posts available in the said two newly created battalions of AISF would be required to be filled up by way of direct recruitment, would be required to be filled up by way of an open advertisement. Also, the petitioner is found to have missed out on a chance, on an opportunity available to him at the relevant point of time when the process of absorption of the ATPSF employees personnel in the newly created AISF battalions were underway. Also,
probably this process was done after these two High Court judgments. Initially, it was not done because 24 October 2016, that was done thereafter.
But you did not appear.
Yes, admittedly, my lord.
Also, in view of the above discussion, this court is of the considered view that direction for reinstatement of the petitioner in his services would not be permissible to so issued after lapse of more than 22 years from the date when the petitioner was ousted from the post, from the ATP FSR. So accordingly, the claims made in the present petition by the petitioner would not mandate an acceptance from petition. Petition is accordingly held to be devoid of any merit and consequently same stand set aside. However, there would be no order as to. Mr. Sharma. So he types it out. I'll make some corrections. You will, in all probability, get the order. You can apply, but you will get it by Monday. So it'll take some time. Salamat Mara. Manu, petition in person. Yes.
Here in this is from 2019 we did.
Two minutes. There is a petition in person. Let me see what has happened. You have appeared before me earlier also.
Lordship,
Which matter?
last time
that series.
yes,
Oh.
IPC. I'm sorry. I mean,
Why didn't you make a mention? You should have made a mention in the morning.
no, I thought it will come. 2817, you pass an order to admit the matter today.
No, matter is admitted. We'll finish it off in the admission
Yes,
stage only. Why should we hear it? We'll hear it in the admission stage.
Yes.
You should have made a mention. You're waiting.
Oh, this, I'm a humble person.
No, you're a petitioner in person here. You will get preference.
Lordship, kindly see page 221.
Mr. A council coming and you coming, we'll give you preference.
No, it's not like that.
No, we'll have to. Yes, sir. Yeah.
2817.
I think I've dealt with this matter. Yes, I have dealt with it.
2817 also.
Tender was issued, Lordship.
But they did not file, they have not filed their objection till now.
So we are not
Not
concerned.
I'm not filing it.
Laha. Heard Mr. P.K. Bhattaji, learned petitioner in person. Also heard Mr.
And
Upadhyay, learned standing counsel irrigation. Mr. You have not filed an affidavit in any.
affidavit filed, Lordship.
Oh.
Affidavit filed in item number 22 and 24. So 22, 23, it will cover. 24, I have filed extra.
Affidavits have been filed already in WPC number 4. Mr. N. Upadhyay, heard Likhisan report. Mr. N. Upadhyay, learned. Mr. N. Upadhyay submits that affidavits have been filed by the respondents represented by him in WPC number 4185/2023 and
Lordship.
6431/2023.
Yes.
6431/2023.
Affidavit filed in Lordship, the first case, Lordship, it covered the second case.
And any other affidavit.
And
2485, Lordship.
2024.
All the three you have filed.
Lordship, 2 I have filed, and my submission will be, Lordship, that
You have filed in which cases?
item 22 and 24.
22 and 24.
Lordship.
6431 to Kata. 2485/2024 and submits that the same would also cover WPC number 6431/2023.
Lordship.
So, you have filed your reply.
He has
Mr.
not filed any
Petitioner in
reply.
person submits that the rejoinder to the affidavits filed have also been brought on record by him. Rejoinders have also been brought to the said affidavit filed by the respondents by him. Full stop. In view of the above, pleadings are complete in the matter. Full stop. As prayed for by the learned counsel, as prayed for by the petitioner in person, and not objected to by Mr. N. Upadhyay, learned standing counsel, Irrigation Department. The matter may be taken up on the next date of listing for final disposal.
Lordship.
But see, there's an IA so there. IA was there linked up.
Everything will come. And that I'll put it, don't worry. When you want
Within
it.
340 days, I'm
Huh? Impossible. It'll go before, after the April. Give me a date.
No problem, Lordship.
Give me a date sometime in April when Undina all of free answer. Bihur agot to he hopta to us, not to hearing Quran. No. Before Bihus, it will be difficult because we'll have a motion week.
You have after
So you will have to keep on waiting. Huh? You can choose a date from after 20th, any date convenient to you.
April.
April.
It is your
No, your choice. You tell me. I'll fix it accordingly.
23rd.
23rd, Thursday. Fine.
Lordship.
On 23/4/2026. Registry to listeners matters again on 23/4/2026 along with the pending interlocutory application. An attempt would be made to dispose of the matters on the next date of listing. Pura ekhopa yate ase enaka yapa itu puri same to enaka. 23/4.
Lord.
And Mr. He comes a long way. I've seen him. Please
Lordship.
don't take an adjournment on that day.
No, Lordship. I'm not.
Mr. Monto,
I'm
your
sitting from the morning, Lordship.
Huh?
Private respondent.
Also heard Mr. D. Monto appearing for the private respondents.
Number 7, Lordship.
Okay.
Lordship.
Yes.
My lord, here I have filed a petition before the my lord register, my joint register, that we could not communicate with my client since
If you want to appear, or I have already dismissed the petition, I'll confirm that.
only my lord writ petition may be with liberty if he allows my he come communicate.
I have dismissed it for default.
My lord, to appear.
If you appear, file an application and get it revoked if he comes. I've not done it on merit. If you are appearing, I'll do it on merit. We have gone through. Nothing is there.
My lord, only we filed petition for withdraw Okalatnama from the case.
That is you don't appear. Today you have not withdrawn. So you are a counsel on record. You have not appeared in the morning, so I have dismissed it for default. But I instructed that if any counsel comes, let me know. I'll sign it only after 4:45.
My lord, that is why
Today, argue the matter or just move away. Let that order be there.
My lord, our appearance may be given, my lord, that is
Appearance given, then you argue on merit. I'll dispose it of on merit then.
on the
All Mr. Day. Day gusi also, you know. Day asil nahi, ek day. Item number given. VK Buru. VK Buru. VK Buru, heard it. Yes. What do you want to do? Argue. Welcome to argue.
Lord,
Matter 17 matter we are not adjourning.
only my lord, it may be day after tomorrow. My
No,
lord.
today, now.
My lord, whatever, my lord, regarding this matter, one KU Ahmed is
Whoever is there,
well aware with the case.
you want to argue, or I'll sign the order. None appears, dismissed. These matters we are not carrying forward. Take a decision. I don't have time. What do you want? Want to appear?
My lord, we argue at this.
Then argue, please. Yes.
Here in this matter, my lord, we are appointed as a my lord cashier. Subsequently, I have
What is the error in the departmental proceeding? Procedure, error? And why the delay in challenging the order of dismissal?
there is a delay.
Two things you answer.
Yes, my lord. Lordship may pass the order, my lord, as per me.
Pass order. I'll hear you. Here. Okay, now you will hear you. Hearing. Tell me about the delay. What is your explanation about the delay?
Come on.
Yes, Mr. I'm not here. This is not a place to read a brief. Tell me.
Only my lord, the petitioners filed a title suit, my lord. That is a title suit was filed in the year 2005, my lord.
Title suit for what?
My lord, for recovery of my payment, my lord, for recovery of payment, which
The
48.
bank filed against you.
My lord, that was recovered from me, my lord. Money 48,000, my lord. And against for that recovery, I have filed title suit. My lord.
Fine, go and pursue your title suit. Who is asking you not to?
That was my lord disposed of, my lord.
Disposed of. Very good. That is immaterial. Here I am concerned with the departmental proceeding.
That was in page, my lord. 43, my lord.
Page 43. Okay, Chief Judicial Magistrate. Okay. This is civil suit.
Civil suit, my lord.
Okay. Now, civil suits are registered as GR case number. In Borpeta, cases are civil cases GR case number.
No, my lord.
Then 43 is that only. That is 51.
Here 43 is for my lord departmental proceeding that
A recovery done away with, nothing like it.
and that is
But what about the penalty?
that
Dismissal.
that is why some delay, my lord.
Huh?
For this reason, some delay, my lord. After my lord acquittal of this page, my lord, page annexer 1843, and
You have
yeah,
been acquitted on
yeah,
the ground of
thereafter-
benefit of doubt, not a clean acquittal. I've gone through it.
and
Ramlal GM Tang will have got no application here. I've not for fun disposed it as for dismiss for default because I've gone through it. I was satisfied. Nothing is there.
my lord.
Yes, you give me your arguments. If you don't argue, I'll dismiss it with cost now. You are wasting the time of the court.
Sorry, my lord.
You argue with me, facts. Convince me I'm with you.
Lord, I pray before your lordship that the matter relating with one K.U. Ahmed, my lord, and he will
Okay.
well aware with this,
Okay.
and I have communicated with
Okay,
him.
deposit 5,000 with the court.
Sorry, my lord.
We will adjourn the matter. Cost for adjournment is not only on the respondents, petitioners also.
Sorry, my lord, that must.
We have wasted enough time now. We can't. We have wasted judicial time. Anything more to argue?
My lord already argued that why To file this, lately filed, delay. I
show
have
me.
actually delay that there.
Delay, why, where have you explained that delay? You have not explained the delay anyway. 2005 to 2017.
Only after acquittal, yes.
Then acquittal and a departmental proceeding and a criminal proceeding, no connection.
We have
Nothing.
filed this.
And your acquittal is only on the basis of benefit of doubt. Beautifully done, department proceedings.
Lordship, up to lordship, my lord. Lordship
Up to me.
Lordship
I can impose cost also.
No, my lord, that is it. No, my lord.
Why you are leaving it up to me? You have nothing to argue. But Mr.
M. Hussain.
M.
Hussain.
Hussain, learned counsel. I'm going to write down what you have exactly said. Please don't mind about that. Mr. M. Hussain, learned counsel for the petitioner. The case was called up in the first round of hearing. However, there was none to press the matter. This court had tentatively decided to dismiss the matter for non-prosecution in the event no appearance is made on behalf of the petitioner during the course of the day. In the second half, Mr. M. Hussain, learned counsel for the petitioner, has appeared and has submitted that he would argue the matter. So, accordingly, this court required Mr. M. Hussain to place his submissions in the matter. Also, heard Mr. M. Hussain, learned counsel for the petitioner. Also heard Mr. Ga Bura, learned counsel appearing for the State Bank of India respondents. Also, the challenge in the present petition is to an order issued by the disciplinary authority imposing the penalty of dismissal from service upon the petitioner. Order dated 29/6/2005 issued by the disciplinary authority imposing the penalty of dismissal from service upon the petitioner. Petitioner has also assailed an order dated 31/12/2005 passed by the disciplinary passed by the appellate authority and an order dated 11/4/2017 passed by the reviewing authority, dismissing his appeal as well as dismissing his appeal and the review petition respectively. So, the petitioner hearing was subjected to a departmental proceeding came to be instituted against the petitioner hearing. Wide issuance of a charge sheet dated 31/3/2004. The petitioner at the relevant point of time was working as an assistant in the Barpeta branch of the respondent number 1 bank. So, the petitioner was against the petitioner, 7 distinct charges were so projected in the said charge sheet dated 31/3/2024. Also, the replies submitted by the petitioner not being found to be satisfactory, a departmental inquiry came to be ordered in the matter. The petitioner participated in the inquiry, and on conclusion of the inquiry, the inquiry officer submitted his report in the matter. Also, the copy of the inquiry report on being furnished to the petitioner, he submitted a representation thereon on 23/6/2005. Also, thereafter, the matter was considered by the disciplinary authority, and on such consideration, the disciplinary authority, by order dated 29/6/2005, proceeded to impose the penalty of dismissal from service without notice upon the petitioner. Also, the period of suspension undergone by the petitioner was also directed to be treated as not on duty, and the remunerations receivable for the said period limited to the subsistence allowance already paid. The petitioner thereafter submitted an appeal in the matter, but the appellate authority, by order dated 31/12/2005, proceeded to dismiss the said appeal. The revision petition filed by the petitioner in the matter was also rejected wide. Revision petition also, it is seen that the petitioner, after the passing of the appellate authority's order on 31/12/2005, affirming the penalty of dismissal imposed upon the petitioner by the disciplinary authority, had not taken any steps for assailing the said orders passed in the matter, and with the passage of time, the said orders had attained its finality without there being any challenge presented to say. The learned counsel for the petitioner has not, the petitioner in the present writ petition has not set out any reason justifying the delay occasioning in approaching this court by way of instituting the said proceeding. In view of the delay and laches occasioning in the matter, this court is of the considered view that the matter would not mandate to be considered on its own, on its merits, and would be required to be dismissed on the ground of delay and laches. In support of the said conclusions reached by this court, this court relies on the with regard to the said conclusions drawn by this court draws support from the decision of the Honorable Supreme Court in the cases Mediation regular. So, in view of the above position, the present writ petition is found to be devoid of any merit, and the same stands. Mr. Ahmed. My lord. Can't help it. Shall I put your name or his name? I do try name, Mr. K.U. Ahmed and Mr. Pranam. After time ID.
Then also, my lord, dismissal benefit. Dismissal benefit comes from obliged, my lord.
I've gone through it. Nothing was there. That's why I
This after acquittal, he approached this court on the basis of.
Can't help it. And Mr. Hussain, start reading files now. Very seriously. You're a senior man now. You should be bold. Tell this court, no, you can't do this. Okay. Attacking this court, not accepting what this court is saying. Be polite. That's
The brief only received by the
that is good. But
after
don't
2
be
p.m.
submissive. Yes.
Brief received only after 2
Yes,
p.m.
yes, I can give you.
Yes, madam.
Yes, Mr. Soma. Amicus curiae. No, amicus curiae from this court. What is the lacuna? Amicus curiae, you're not common counsel now, amicus curiae.
Lordship, procedures followed. And his main ground is that he don't understand Hindi language, but in record, his own application is in Hindi language. The expertise, because we have provided all opportunities. In that case, there is, as for us, Lordship, there is nothing wrong in the.
Yes, what is the procedural error?
Only thing is that, Lord, times and again, I file an application that I do not understand.
But you filed your applications in Hindi only. How did you file that application?
That was application filed by separate person, my asked and.
At the learned counsel for the parties at some length, hearing remains inconclusive. Registry to list this matter again on Bond Bishop, 23 for further hearing. I'll dismiss it, but not today. Two dismissal together in one case, not good. Your this plea, Hindi. Oh, it was no. Tur kiba lamba ta hase nahi pending. Na itu eta hai. Boiling. But Mr. K. Singha, learned counsel for the petitioner, also heard Mr. S. Bhuya, learned standing counsel, higher education department. Also heard Mr. S. Datta, senior counsel, appearing for the respondents number 3 and 4. 3, 4 and 5. And Mr. A. Das Gupta, learned senior counsel, appearing for the respondent number 6. Meeting it also, no? Kali ki budpa. The petitioner in the present writ petition has essayed the appointment effected in case of the respondent number 6 as assistant professor, Department of Commerce, Gurucharan College, Silchar. The petitioner further prays that a direction be issued, Madam, direction be issued to the respondent authorities to appoint the petitioner against the post. The respondent number 6 was so appointed by reckoning his merit position, her merit position obtained in the connected selection process. At the outset, it is to be noticed that the learned counsel for the parties have apprised this court that during the pendency of the present writ petition, the petitioner, in terms of her selection for the post in question, was appointed as assistant professor in the Department of Commerce, Gurucharan College, Wide, an order dated 13/11/2025, issued by the Director of Higher Education, South. Accordingly, in the present writ petition, the relief that would be permissible to be granted to the petitioner would be whether the appointment now effected in her respect is to be given a retrospective effect, that is with effect from the date the respondent number 6 was so appointed, and if so, with what further consequential benefits also. Next para. The authorities of the Gurucharan College, bracket hereinafter referred to as the college, bracket over, upon receipt of due approvals from the Director of Higher Education, Assam, had proceeded to issue an advertisement dated 27/1/2021, inviting applications from eligible candidates for filling up of vacant posts of assistant professors available in various departments of the college, including the Commerce Department. They set advertisement. Why they said advertisement? 2 posts of assistant professors in the Department of Commerce of the said college was put up for recruitment. The said 2 posts were so placed were put up for such recruitment for unreserved community candidates against rooster point number 1 and 4. Also, the petitioner hearing being petitioner and the respondent number 6 being eligible for recruitment against the post of assistant professor in the Department of Commerce as advertised. What they said advertisement did it. Had submitted their respective candidature for the same along with 59 other candidates. On the receipt of the applications and scrutiny being made thereof, the college authorities had shortlisted 55 candidates for the interview process for the selection, holding them to be eligible for the purpose and issuing to them call letters. Full stop. Accordingly, the petitioner and the respondent number 6 appeared for the selection, which was held on 1/12/22 and 2/12/22. In total, 27 candidates had appeared in the selection process. Also, the materials brought on record reveal received by the petitioner, received by the petitioner under the provisions of the RTI Act reveal that on conclusion of the selection process, the selection committee had recommended the name of the petitioner at serial number 1 and that of the respondent number 6 at serial number 2 for recruitment against the 2 posts of assistant professor available in the Department of Commerce of the college in question. The placement of the petitioner and the respondent number 6 by the selection committee in the above manner was on the basis of the merit position obtained by, was on merits, full stop. Next, subpara. The petitioner at this stage came to learn that the respondent number 6 was appointed in the college, in the Department of Commerce as an assistant professor, and she being denied of a due appointment, although was placed on merits above the respondent number 6, proceeded to make inquiries in the matter. The inquiries made by the petitioner revealed that she was recommended in terms of her selection for appointment against a rooster point number 1, while the respondent number 6 was so recommended for appointment against a rooster point number 6. However, after the recommendations were so made, a confusion had arisen as to whether the rooster point number 1, who is to be so reserved for unreserved PW-D category candidates. Accordingly, a clarification in the matter being sought for from the college authorities, further processing with regard to the appointment of the petitioner in terms of her selection to the post of assistant professor was kept in abeyance, and there being no confusion with regard to the rooster point number 4, the respondent number 6, the case of the respondent number 6 was processed and order appointing him was so issued. Also, it is in the above background that the above background that the petitioner has instituted the present petition with the reliefs as noticed therein above. Tomorrow, Thursday. First item. Order my decision. The matter, due to paucity of time, the order could not be passed. Accordingly, registry to list this matter again on Thursday, 19th. Anything urgent? We'll have to rise. There is a meeting.
But 27 may come on 10th, 10th of April. Some similar matters are fixed on that day also. It's that
On the
regarding.
prayer of the Learned Council for the petitioner, registry to list item number 27 on 10/4/2026.
Also, item number 30 and 31.
Hmm.
In fact, already hearing was concluded and the Learned Council for the petitioner has also submitted a written argument also. So in between, the matter was listed before other bench also.
Matter went away from me.
Otherwise,
Then my latest and back.
31, registry to list those matters again, as prayed for by the Learned Council for the parties. We'll have to apply my mind again. Registry to list those matters again on,
after
23/4/2026. Then? Yes, Mr. Das.
Item 32, Mayor.
32,
Alright.
32 order, 32 fine to the other. We'll extend the time for mediation. Heard the Learned Council for the parties. So, the matter was sent for mediation and a mediator was also appointed in the matter. The parties have also appeared before the mediator and the process of mediation is currently pending. The mediator has submitted an application dated 16/3/2026 and therein has highlighted that there is a possibility of settling the dispute in the mediation process. Accordingly, has requested for requested further time for 1 month. Requested further 1 month time to complete the mediation process. So, the Learned Council for the parties have not have also agreed to continue with the mediation process. So, accordingly, registry to require the appointed mediator to continue with the mediation process and conclude the same at the earliest with the submission of the report of the mediator. So, accordingly, for the purpose of completion of the mediation process, registry is directed to list this matter again after 45 days from today. So, the parties to the proceeding, to the mediation, shall appear before the mediator. Give me a date. Let the mediator in. So, the mediator will now fix a date in the matter and intimate the same to the parties involved. So, and thereafter take the process of mediation forward. Also, registry to list enough 45 days on a date to be fixed by. Oh, it will be further hearing. It continue. Seven 4 minutes. Anything?